God, this honorable court, and the fellows of the American College of Trial Lawyers.
Please be seated, especially the following. I want to apologize to the council that we know I expected to see Judge Barnes because of her surprise appointment to the Supreme Court this morning. I'm asked to stay. So I may not be as familiar with your files as I could be, and I'll apologize in advance for that and for nothing else. So I understand that we have Lars Pulsibus and Amanda Tuminelli from the state.
Yes, Your Honor.
Yes, Your Honor. Good morning, or good afternoon, sorry.
And we have Michael DeTore and Samantha Lemke.
Yes, Your Honor. Afternoon.
Yes, Your Honor.
Before we begin, I know we had an abbreviated audio, and I want the members of the jury to have opportunities to tell you who they are. And I need to do this as an aside. I don't want to take your valuable time in this trial. We have a lot of war stories told by each of the members of the jury. I will tell you the one thing they have in common. They are diverse, as all human beings are. They're as diverse as snowflakes. They each have their own individual stories. But they have one thing in common. They are all fellows of the American College of Trial. And I want you to know that means that they are all very special. In order to be a member of that institution, you have to have been trying cases for a minimum of 15 years. You have to have tried a lot of cases. You have to have tried them so well that you were considered to be among the 1% in your jurisdiction, 1% of all practicing lawyers. So these are a special group. They come from all across the country to be here today. I'm going to ask them to simply stand up and tell you who they are. Can we start with you, Judge Layton?
I'm Ron Layton. I'm from the Western District of Washington, United States District Court.
I'm Karen Townsend. I'm from Missoula, Montana, and I'm a district court judge, which is a general jurisdiction judge in Montana.
John Phillips from the firm of Phillips, Parker, Herberson, and Arnett in Louisville, Kentucky.
I'm Gary Winters from Cincinnati.
My name is Paul Gutierrez, and I'm from San Francisco.
Marty Jones, I'm from Armadillo. C.E. Rhodes, that's Charlotte Elizabeth, president of the Texas Inland Association.
I'm Larry Krantz from New York City, and my firm is called Krantz & Burns.
Tim Helfrich from Ontario, Oregon.
Good afternoon, I'm Pamela Mackey. I'm a criminal defense lawyer from Denver, Colorado.
My name is Chuck Dick from San Diego, California.
I'm Ed Cronk from Birmingham, Michigan.
George Pappas with the firm of Covington and Burlington, Washington, D.C.
Rufus Pennington, sole practitioner, Jacksonville Beach, Florida.
Rodney Acker, Fulbright, Jaworski, Dallas, Texas.
David Kittner, in the last 15 minutes of his fight, quite good. I'm from Dallas, Texas.
I am Escobedo, judge in the trial court of general jurisdiction, Houston, Virginia.
Deborah Cole from Sidney Austin, Los Angeles.
Kathleen Flynn Peterson from Minneapolis, Minnesota.
I also want to acknowledge a few of the departed. We had other people that were here earlier this week. Leon Carter from Texas, Mike Clancy from Illinois, Kate Deming from Georgia, Christy Jones from Mississippi, Don Davis from Texas, Brian Jackson from Louisiana, T. John Ward, chairman of this committee from Texas, will be back here tonight for the final ceremony. All of them came from all of those places to also be here with you. And we all thank you for being here. This is your one opportunity very quickly to thank them for being here. So let's proceed now with the trial. Before we do that, I have to warn the counsel that at 3:30 or so, as close to that as possible, we need to take a recess so that I can plan tea times for next week. During the presentation, so bear in mind that I may ask that things go a little out of order so that we can adhere to that schedule. And we have any preliminary matters before we begin?
Yes, Your Honor. Samantha Lemke, along with my co-counsel, Mr. Michael DeTore. We represent the defendant in this case, Dr. John Martin. We have two motions in limine to present to the court today.
All right, proceed.
To give you some context for our motion, this case is about a 65-year-old lifelong drug abuser who on May 9, 2011 suffered a fatal heart attack, and his doctor, Dr. John Martin, has been wrongfully accused as being responsible for that death. The defense's first motion is to exclude any evidence of a Vicodin bottle, as it is irrelevant and it means no exception. I'm sorry, it's hearsay and it meets no exception in this case. Would Your Honor like a courtesy copy of this?
No, I've seen the copy of the proposed exhibit.
Yes, Your Honor.
What's your position on why it's irrelevant?
Well, or I'm sorry, not that it's irrelevant, that it's hearsay and it meets no exception. We anticipate the state will try to elicit this information, this evidence, through their witness David Kittner Jr. on his direct examination. However, there are 3 hearsay assertions, namely that the bottle was prescribed for Vicodin, that it was prescribed to David Kittner Jr., and that it was prescribed by Dr. John Martin. These hearsay assertions meet no exception and may be offered for the truth of the matter asserted. Therefore, they should be excluded.
Yes, Your Honor. Once again, Lars Holzebus for the state of Lone Star, along with Amanda Tuminelli. The bottle, which has been pre-marked Exhibit 1 that counsel is talking about, is a piece of physical evidence that was found at the scene. It's a bottle of Vicodin that was found next to the medicine bag of the defendant.
My understanding of the argument is that it's a bottle of something, whether or not it's Vicodin, it is hearsay going on later.
Your Honor, it's been stipulated that the exhibits in this case are authentic, and that my understanding of that rule is that...
picture of the bottle.
Yes, Your Honor.
But if the bottle simply says Vicodin, why does that make the contents Vicodin?
Your Honor, again, my understanding of the stipulation is that these exhibits are what they purport to be. Now, this exhibit purports to be a bottle of Vicodin. There are no assertions on the bottle. This is what it purports to be, and it's actually a legally operative fact, Your Honor. This is a bottle of Vicodin. The prescription actually entitles the holder to that Vicodin, and so even if it...
Was there a stipulation that this is a bottle of Vicodin?
No, Your Honor, the stipulation is that all the exhibits in the file are both authentic and original. However, although this is a bottle with a prescription label on it, the hearsay assertions on the prescription label are inadmissible evidence.
Let me assume for a moment that there is no stipulation that it's Vicodin. Let me also ask whether or not you have an opinion as to whether or not there's some reason that should come in apart from whether it's actually Vicodin.
Well, yes, Your Honor. In fact, we intend to enter it to offer that this bottle was not prescribed to David Kittner Jr. Now, that's one of the, what counsel has called an assertion. I don't believe it is an assertion, but even taking her at her explanation that this is an assertion, we intend to argue that that's not true, that this wasn't actually prescribed to David Kittner Jr., but it was, in fact, prescribed and given to David Kittner Sr. So it's not going to be offered for the truth in this case.
Anything further?
Your Honor, the fact that it says David Kittner Jr. is a hearsay assertion along with the multiple other assertions on this label. The fact that counsel intends to argue it for something else, it's still being argued for the truth of those assertions.
Well, I'm going to rule that the fact that this bottle was found at the scene may come in. The state cannot argue what its contents were unless the state has a witness to verify what the contents were. Nor can the state argue what the meaning of the bottle is unless you have a witness to tie it up.
Yes, Your Honor.
Your second motion, Your Honor?
Yes, Your Honor. Defense's second motion is to exclude any evidence regarding actions Dr. Martin allegedly failed to take on May 9, 2011, as they're irrelevant in this case. As Your Honor knows, this is a charge of reckless manslaughter, meaning that what's at issue are any alleged actions that Dr. Martin took May 9, not actions he failed to take. Bringing in evidence of actions he failed to take would go to negligence, and it would only serve a high risk of juror misuse and confusion. It would not go to...
Position counsel that failing to act can never be reckless?
I believe failing to act might be reckless in some cases. However, the charge in this case specifically is that Dr. Martin allegedly acted recklessly by injecting his patient with either propofol or adrenaline when he knew there was a substantial risk that could cause his patient's death. He's not charged with recklessly failing to act. He's charged with specific reckless actions. Having evidence come in as to what he failed to do, for instance, failing to call 911, would be evidence of negligence, Your Honor. It would confuse the issues, and it would allow the jury to disregard Your Honor's instructions in this case and on this charge.
Defense?
Yes, Your Honor. I disagree with counsel that the failure to act can never be reckless. And in fact, Your Honor...
She said that she backed off on that.
Yes, Your Honor. Now, whether or not these actions would be strictly relevant to the exact charge of recklessness, they still may be probative. The fact that he failed to call 911 may be probative of the fact that he did not act as a physician should on that day. It may be probative of the fact that of a consciousness of guilt. It may be probative of a number of things in this case, and it doesn't specifically have to go to whether or not he actually administered the drug.
Counsel, I'm going to deny your motion mainly because I'm not sure how I would divide the line at this point. We are going to be very careful. The instructions are going to be that for conviction has to be reckless, not negligent conduct. And the line gets crossed, remind me again, motion to eliminate is preliminary rule.
Yes, Your Honor. With that, the defense has no further motions in limine. However, we would seek to enter into evidence exhibit number 5, as it's been stipulated to bind between both parties that this is an original and authentic photograph depicting Mr. Kittner as he was at the time of his death.
Any objection to exhibit 5?
No, Your Honor.
All right, then it will be admitted. Does the state have any motions?
Yes, Your Honor. Well, we have 2 motions as well as some preliminary matters. Which would you like us to address first?
Start at the beginning, as they say in Alice in Wonderland.
Yes, Your Honor. Your Honor, all the exhibits, as we've already talked about, a few of them in this case are referred to by a pre-marking system. I assume at this point we can adopt that pre-marking system, both sides, and refer to them by their numbers.
Of course.
May we be allowed to use the well during examinations and opening and closing?
We have a water pump here in the courtroom. Oh, you mean the area?
The well in the courtroom, yes, Your Honor. I apologize.
You can use whatever part of the courtroom you want.
Thank you, Your Honor. Would you like us to ask to approach the witness and the bench and opposing counsel?
You may freely approach, but you may not accost any witness.
Yes, Your Honor. I'll try not to. And also, can we assume that all objection arguments are made outside the presence of the jury to avoid the necessity of escorting them out? Yes, Your Honor. With that, we have 2 motions in limine to deal with. The first, as counsel stated, this case is about the death of a man named David Kittner, Sr. Now, Mr. Kittner was a famous rock star, as I'm sure you well know. Our first motion is to exclude an article about Mr. Kittner written in Rolling Stone magazine. It's been pre-marked as Exhibit 7. It's available on page 43 of the case packet. It's a 2-page exhibit. The first page is merely the cover of Rolling Stone, and the second page is the actual article. This article was written by someone who was not here to testify, can't be cross-examined. The article itself is hearsay and also contains hearsay statements made by a number of parties.
Your Honor, we don't seek to go into this evidence, therefore we can join in the motion.
Okay.
Our next
It
motion.
would have been easier if you just consulted with counsel.
Yes, Your Honor, I apologize. Your Honor, we also seek to exclude Exhibit 4. Exhibit 4 is on page...
Is there going to be any question about that?
Yes, Your Honor, we do anticipate eliciting evidence about Exhibit 4.
All right, then you need to proceed.
Yes, Your Honor. Exhibit 4 appears to be an entrance questionnaire from a health clinic. It says Golden Dock Health Clinic at the top. It's been filled out in pen, and it says it's been filled out by David Kittner, although there's no way to know that for sure. Now, for the same reasons that the counsel just asked to have excluded the pill bottle and the writing on that pill bottle, I believe that this, Your Honor, is also hearsay evidence that should be excluded.
May I respond?
Of course you
For one, Your Honor, this document, this is exactly where the stipulation that we discussed earlier does come into play. Counsel stated that this appears to be a document filled out at a health clinic. This is an authentic and original document. It was filled out at a health clinic by David Kittner. Furthermore, the fact that it's a document filled out by David Kittner at a health clinic is a statement made for the purpose of medical treatment or diagnosis. It fits a hearsay exception. It's really admissible under that.
May I respond, Your Honor? The statements made for a medical diagnosis exception requires that it was actually the patient making the statement. Now, it hasn't been established, and it can't be established by offer of proof by any evidence in the record that this was made by David Kittner. Mr. Kittner obviously is deceased. He can't come here to testify that he filled this out.
I thought we had a stipulation as well, because there's no question here that this is the senior Mr. Kittner, given the age of 65.
Well, there's a question of whether he filled it out at all, Your Honor. For the same reason the bottle says Vicodin but might not have Vicodin in it, this might say David Kittner but not be David Kittner.
Nice try, Basil, but your goose and my gander are matching one another.
Yes, Your Honor.
Are we ready to proceed?
Yes, with that, Your Honor, the stage is ready to proceed.
You may call your first witness.
Would it be all right if we give an opening statement first, Your Honor?
I hate opening statements, so I was hoping you would just sort of
May it please the court, counsel, ladies and gentlemen of the jury, let me tell you about the best benefits package any doctor has ever gotten. $150,000 a month, residence in a 12-bedroom, 15-bathroom mansion, complete with pool, guest house, cabana, fitness center, skeet range, and 7-person live-in staff. What does a doctor have to do to get a benefit package like that? That's easy. See one patient. But the catch is that doctor has to do whatever that patient wants, even when that patient asks for prescription drugs the patient doesn't really need. That's what this defendant did. The defendant went from being the victim's doctor to his drug dealer. And then he killed him. Today, the people of Lone Star have charged Dr. Martin, the defendant, with manslaughter. We intend to prove that on May 9th, 2011, the defendant injected Mr. Kittner with a combination of prescription drugs that caused his heart to fail, caused him to die. We intend to prove that he acted recklessly, meaning that he knew about a risk and he disregarded that risk. Mr. Kittner, as many of you know, Mr. David Kittner was a rock and roll star, a music legend. And it's his death that brought us here today. We will bring 2 witnesses to speak to you about the actions of the defendant on May 9th, 2011. Now, the first person you're going to hear from today is somebody who witnessed the events firsthand. Somebody who was directly affected by Mr. Kittner's death. And that's his only son, David Jr. David Jr. will tell you that he was at the mansion on the day his father died, and he heard his father roaming around the house asking for pain medication, saying he wasn't feeling well. David Jr. will tell you that he went into his father's bedroom to see what was wrong, and what he saw when he walked in was the defendant injecting his father with a syringe. Then the defendant left the room. He left the 17-year-old son of that man to watch that man turn pale, start to shake, and stop breathing. David Jr. will tell you that he rushed back into the hallway to find the defendant, but the defendant was nowhere in sight. Minutes go by. Finally, the defendant comes back and, again, injects David Jr.'s father with yet another syringe. David Jr. will tell you that it was that second injection that ensured his father would not recover. He'll tell you he died right there in his own bedroom. Our next witness, Dr. Chris Jensen, will explain that it was the combination of drugs in those 2 syringes that ensured Mr. Kittner's heart would fail and he would die. Dr. Jensen is the chief medical examiner for the state of Lone Star, and she'll tell you that she performed the autopsy on Mr. Kittner. And she'll tell you that her examination revealed 3 drugs in Mr. Kittner's system. That's hydrocodone, adrenaline, and propofol. And you're going to hear a lot about propofol throughout today's trial. I want you to listen to what it's supposed to be used for and where it's supposed to be used. Dr. Jensen will tell you that propofol is a sedative. It's an anesthetic. It's used for anesthesia, which makes sense because she'll tell you that it's supposed to be used in a hospital in a carefully controlled and monitored environment. Dr. Jensen will also tell you, based on her medical experience, what the defendant should or should not have been doing on May 9th, 2011. She'll tell you that propofol, when a doctor administers a drug like that doctor needs to be absolutely certain about what drugs their patient is on before they ever administer propofol. Dr. Jensen will tell you that the defendant had no business injecting Mr. Kittner with propofol or adrenaline, let alone in combination, on May 9th, 2011. By the time Dr. Jensen leaves that stand, you will understand why Mr. Kittner died, and you will know that it's the defendant who is responsible for his death. The Third, you're going to hear the words of a woman named Bree Trevino. Ms. Trevino is not available to come speak to you in person today, but you're going to be able to hear her words. And you're going to hear what she saw on May 9th, 2011. Ms. Trevino was the defendant's girlfriend at the time, and she'll tell you that they were out in the cabana where the defendant lived, drinking alcohol, smoking marijuana, and listening to music. And she'll tell you that when the call came in from Mr. Kittner asking the defendant for help, before the defendant picked up his medical bag and walked into the house, he turned to her and he said, "I'm going to go fix him once and for all." 15 minutes later, the defendant came back into the cabana, he turned to her again and he said, "I fixed the problem." And then they went back to drinking alcohol and smoking marijuana and listening to music. Now, throughout today's trial, you're going to hear some negative things about Mr. Kittner, specifically about his drug addiction. But you're also going to hear that he was trying to get help. He was trying to get clean. You're going to hear that he placed his trust in the wrong person, his doctor, somebody you'd think would be there to help him. But instead, the defendant fed Mr. Kittner's addiction. You're going to hear that he went from being his doctor to his drug dealer. And at the end of this trial, my co-counsel will come before you and ask you to find the defendant guilty. Why? Because when you ask yourselves, who in that house had drugs? Who in that house had a medical bag with a pre-filled syringe? There will be one answer. The defendant. Thank you.
If Your Honor will allow me. Thank you.
David Kittner was on a road to destruction. David Kittner was Dr. John Martin's friend. He was his patient. He was also a drug addict. And on May 9, 2011, his lifestyle caught up with him. He began to experience shortness of breath. He was in pain. He called his doctor to tell him about these symptoms. Dr. Martin goes up to Mr. Kittner's bedroom to see him. Mr. Kittner asked Dr. Martin for a drug called propofol, a sedative, a surgical sedative. Dr. Martin, knowing that there's no reason to give him this drug, flat out refuses. When Dr. Martin steps out of the room, you're going to hear Mr. Kittner did convince someone to give him the propofol that day. And that propofol, once it hit his heart, it made the heart attack he was experiencing go into full swing. 911 is called, a medical team arrives. Mr. Kittner receives a shot of adrenaline that day. That adrenaline, that propofol, on top of a lifetime of drug abuse, on top of obesity, on top of a laundry list of health problems, on top of other illicit drugs in Mr. Kittner's system, on top of the Vicodin he was taking behind his doctor's back, it was too much for his heart to take. The heart attack that was already occurring that day stopped his heart, and he died. Dr. John Martin did absolutely nothing that day to cause David Kittner's death. Members of the jury, I want you to meet Dr. John Martin. Dr. Martin's from right here in Lone Star. Born and raised, went to high school here, college here, and medical school. He opened up a medical practice here in Lone Star to cater to the members of our great state. And when he was a young man, he met David Kittner. They became great friends. Mr. Kittner asked Dr. Martin to be his personal physician, a position he gladly accepted. You're going to hear today that Dr. John Martin cared for Mr. Kittner greatly, that he is in no way responsible for Mr. Kittner's death. And to understand why he's not responsible, you have to understand what really happened on May 9, 2011. You're going to hear that on that day, Dr. Martin was where he usually was. He was in the house, the cabana, outside of Mr. Kittner's house. Mr. Kittner allowed him to live there to function as his personal physician. On that day, he gets that phone call to Mr. Kittner. Mr. Kittner is saying, "I'm short of breath, I'm in pain." Mr. Kittner is experiencing the symptoms of that heart attack, though neither of the men knew it at that time. Dr. Martin starts asking him questions about what he's doing. Mr. Kittner said he'd been exercising. Dr. Martin, knowing that Mr. Kittner has had drug problems in the past, well, he flat out asked Mr. Kittner, "Have you been doing any drugs?" Mr. Kittner said, absolutely not. He swore to Dr. Martin that he was not on any sort of drug. And so based on what Mr. Kittner told Dr. Martin, not based on what Mr. Kittner kept from him, Dr. Martin attributed those symptoms to exercise. But Mr. Kittner wanted Dr. Martin to come up to his bedroom and speak to him more, and so Dr. Martin grabs his medical bag and heads upstairs. He gets to Mr. Kittner's bedroom, and those symptoms are a little worse. But Mr. Kittner starts asking Dr. Martin, makes a demand of him for a drug called propofol. Dr. Martin again knows there's no reason to give him a surgical sedative. He has no medical condition for which we require propofol. So he refuses. And you're going to learn, despite what you may have just heard, Dr. Martin refusing to give Mr. Kittner drugs was not uncommon. In fact, you'll hear Dr. Martin refused Mr. Kittner's requests regularly. You're going to hear evidence, in fact, that there is no way Dr. Martin could have known Mr. Kittner was on hydrocodone at that time, and you're going to know at the end of this trial that he did not prescribe Mr. Kittner hydrocodone. And so right after he refuses that next request on May 9th, that request for propofol, Mr. Kittner Jr., the son, comes storming into the bedroom, screaming at Dr. Martin. Dr. Martin steps out of the room after getting screamed at, and at that point, it's just Mr. Kittner, his son, that medical bag, and inside that medical bag, a syringe of propofol, the drug that Mr. Kittner had just asked for. Sometime after Dr. Martin had left that propofol, it's put into Mr. Kittner's system. And it's put into his system in 3 times the medical amount. 3 times the amount a doctor would give in a medical dose. Administered, not how a doctor would do it, but rather how someone who doesn't know how the medication works would do it. Sure enough, when Dr. Martin comes back to get that medical bag, he sees David Kittner Jr., a syringe in his right hand, slipping it into his boot, concealing something else in his left hand, hiding it behind his back. What you're going to hear today is that Mr. Kittner Jr. was never investigated and that syringe was never found. What you're going to hear, there was a pill bottle found right where Mr. Kittner Jr. was standing, right by his father. Now, Mr. Kittner receives that propofol. His heart attack that he's experiencing that day now is in full swing. His symptoms are flaring. 911 is called. EMTs arrive. They swarm him and start treating him. And it's at that point Mr. Kittner is given adrenaline. Those drugs, on top of his obesity, on top of the cocaine in his system, the THC, the ketamine, the sodium hydroxide, and aluminum powder you'll hear were in his system, on top of years of abuse to his body. It's too much for his heart to take. And his heart stopped. Dr. Martin's friend for decades. He's dead. And that's what happened on May 9th. And despite that, the state is here alleging 2 things. 2 things that they must prove to you, members of the jury, they must prove to you beyond a reasonable doubt. 1, they have to prove Dr. Martin was the one who injected the medications that day. 2, that it was those drugs that were the direct cause of Mr. Kittner's death. Now, to prove that it was Dr. Martin who injected those drugs, they will only bring forth 1 witness. That 1 witness is going to be Mr. David Kittner Jr., the one who was seen that day with the syringe in his hand, concealing something else in the other. And to prove it was those drugs that caused Mr. Kittner's death, they'll bring forth only 1 witness, a witness named Dr. Chris Jensen, who, despite the fact that that laundry list of drugs was found in Mr. Kittner's system, despite the fact that he was in general terrible health, that he was overweight and had led a rock and roll lifestyle, despite all that, will say that it was just these drugs that caused his death. But the fact of it is, we don't know what caused Mr. Kittner's heart attack. We don't know when it started. You're going to hear that from another doctor. Dr. Walker is going to come before you here today. Highly qualified and educated in her field. She's going to come before you and talk about what we know about what caused Mr. Kittner's heart attack. And unfortunately, it's not much. We don't know. She'll tell you that after she reviewed all the medical records, the autopsies, Mr. Kittner's medical records specifically, and all the documents in this case, when she discovered all of those vices I've told you about and the damage that they caused to the body, she just said, it is absolutely impossible to tell what caused Mr. Kittner's heart attack, when it began. It is impossible to determine medically what caused Mr. Kittner's heart attack or when it began. And lastly, you're going to hear from Dr. John Martin himself. He has a Fifth Amendment right not to testify, but he's going to waive that. To come before you, members of the jury, and speak to you, and tell you what happened on May 9th, 2011. He'll tell you that he didn't inject the thing that day. And he did nothing that day to cause Mr. Kittner's death. And that's why the state is going to fail to meet their burden here today. Because Dr. Martin did not inject a thing in Mr. Kittner that day. And they cannot meet their burden as to what actually caused Mr. Kittner's death. And because of that evidence, ladies and gentlemen, because of that lack of evidence, at the end of this trial, you'll have a duty. My co-counsel, Samantha Lemke, will come before you at the end of this trial and ask that you fulfill that duty. And that's to return a verdict that fits with the facts, fits with the evidence, that fits with the truth. And if you do that, there's only one verdict you can reach. Dr. John Martin is not guilty.
Yes, Your Honor. State of Lone Star calls David Kittner, Jr.
We have a stipulation to all this, sworn.
I think that's your preference, Your Honor.
While we wait to work, as soon as they are, anybody who can testify today, you swear or affirm the testimony you will give today will include the whole truth and nothing but the truth, so help you God.
I do. Thank you, Your Honor. May I proceed? Please introduce yourself by stating your name for the jury.
My name is David Nellie Kittner, Jr. I go by Little Kid, or as my new girlfriend, P-Mac, Pamela Mackey, calls me, a big kid.
Well, I'm going to call you Mr. Kittner, if that's all right.
That's fine.
Now, Mr. Kittner, how old are you?
I'm 19 years old.
Now, are you the son of the late David Kittner, Sr.?
I am.
How old were you when your father died?
I was 17.
Did he die on May 9th, 2011?
He was killed on that day.
Mr. Kittner, can you tell us a little bit about your father?
He's a great man. I think a lot of people know him. He was a rock star, a rap star, a country star. He lived a good life, and I miss him dearly.
You said he was a star, and you listed some genres. I take it he was a pretty successful musician.
He was. He went from everything from his real name to his rap name of Special K, and he was extremely successful in his business. I was very proud of my father.
Did you live with your father before he died?
Oh, absolutely.
Where was that?
We lived right here in Armadillo.
Is that in Bear County?
It is.
Now, where in Armadillo did you live exactly?
Well, it was right there on the southwest side of town. You know, it's a little windy out there, but you know, if the feed yards aren't blowing in, it's actually a pleasant place to live.
Was that a house that you two lived in?
It was a good sized house. I joke about it as being the little house, but it was a pretty sizable property. We had about a 15-bedroom main house. Had a house out back with 3 bedrooms, 4 baths. Had a skeet range where Ted Nugget used to come over, shoot skeet, and occasionally bring the elementary kids over to show them how to butcher a cow. Don't ask me why he did that, but he would. And then we had a little guest house on the other side of the skeet range.
Now, just so the jury knows, you mentioned someone named Ted Nugget. Who's that?
Oh, he was a buddy of my father's. They used to go crossbow, shoot skeet. I'm surprised they didn't shoot each other from time to time, but he's a neat guy to know growing up.
Was Mr. Nugget a musician too?
He is. I don't know if my father met him first or if it was Uncle Roofy, as we call him, that started hanging out with Nugget, but that's how we got to know him.
Now, was there anyone else who lived on this property that you just described?
Yeah, there were people that were always around. I can tell you that in the Cabana house, Dr. Martin and his girlfriend lived there. We had a maid, we had a cook, a fantastic fitness instructor. I'll never forget Kathleen. She may have made a man of me, but she was something else. There was Deborah Pohl, who was our AV girl. She was something else too. But Marvin Jones, before he got rid of the
I just want the defense to know that I'm here and available if you have any objection.
The only other people there was the gardener, Marvin Jones. He's the one who shaved his mustache because of his habit, if you know what I mean. But that's about it. Had about 7 other people on the property.
Mr. Kitchener, it's not that I'm not enjoying your testimony, but if we can try to keep the answers just a little bit.
Certainly.
Now, you mentioned that Dr. Martin lived there. When you said that, did you mean Dr. John Martin?
Yes.
Do you know Dr. Martin?
Yes, I do.
Would you recognize Dr. Martin if you saw him?
Yes.
Do you see him in this courtroom today?
Yeah, he's the little short, pudgy guy right over there.
Your Honor, may the record reflect that the witness has accurately, if crudely, identified the defendant as Dr. John Martin.
I would object to that.
Thank you, Your Honor. Now, you also mentioned that Dr. Martin's girlfriend, I think, lived there?
Yes.
Who was that?
We knew her as Tatwoman, but it was Bree Trevino who lived there.
Now, after your father passed away, you told us he was a pretty successful musician. Who got most of his estate?
I actually inherited all of it.
Now, did you expect to inherit all of his estate before he died?
No, I mean, I am his only son, but I mean, nobody goes into it, especially when you're 17 years old, thinking about what you may or may not inherit. I think that was probably the furthest thing from my mind at that point.
When did you actually found out that you were going to inherit your father's estate?
It was about 2 weeks after my father's death when the lawyer came around, pulled the family together, and that's basically when I found out.
Now, Mr. Kittner, I'd like to talk about the day your father died. Can you tell me when that day you first realized that something strange was going on or something was wrong?
I mean, it was a normal day until I heard my dad in the hallway. He was asking about pain medication.
Now, did your father have an injury that you knew of at that time?
Not that I was aware of.
Did you know anything about whether your father used drugs at all recreationally?
I think everybody knew that my father had his run-ins with drugs over the years. I mean, he lived the life of a rock star. And I guess we had all the hope he kicked it, and I thought he did.
Now, Mr. Kittner, you mentioned you overheard your father asking for pain medication. What did you do, if anything?
I immediately went out in the hall just to see what he was asking about and what he needed.
Did you see your father out in the hall?
I did not.
What happened next?
Well, the hallway leads down to the bedroom, so I go down to the bedroom, poke my head around the door, and there was my father on the bed.
You said you saw your father on the bed. Was that his own room?
Yes, it was.
Now, was there anybody else in that room at the time?
There certainly was.
Who was that?
Dr. Martin was also in the room.
Now, you said your father was on the bed. Where was Dr. Martin in relation to your father?
He was right beside him, hovering over him.
Did you notice that anything that Dr. Martin was doing or holding at that time?
Yeah, he was holding a syringe. Had it in my father's arm, pushing the plunger down, injecting my father with something.
Now, after you saw Dr. Martin inject your father, did you hear Dr. Martin say anything?
Yeah, he said you just can't kick the stuff, or you just can't leave the stuff alone, can you?
Now, after you heard the defendant say that, what happened next?
Well, he had took the syringe, and I don't know how to explain it. It was kind of sneaky like. Nobody else is around.
Speculation, Your Honor. May I be heard outside the presence of the jury?
You may.
This witness can't testify as to the state of mind of Dr. Martin, testifying that he was doing something in a sneaky way as speculative.
May I respond? The witness was trying to use his own words to show his lay opinion. This is allowed under 701. He said, I don't know exactly how to describe it, but it was kind of sneaky like. That's the kind of opinion that a lay witness can make.
Let me just caution you, Mr. Kidner, that you're allowed to tell the jury what you observed, but you can't characterize it. So try to limit yourself to what you actually saw and describe what you saw.
Yes, sir. The best way I can describe it, he takes the needle out again after putting it in my father, takes that needle, opens his jacket, and just kind of puts it in there and hides it away.
Now, do you know if Dr. Martin had seen you at this point?
Quite certain he had not.
Objection, speculation.
Sustained.
Your Honor, move to strike the witness's last statement.
I wasn't sure that it had gotten out, but it was yet. The jury will disregard any answer to that question.
Mr. Kittner, what happened after Dr. Martin put that syringe into his jacket?
Well, it's about that same time. I told you what my father said, or what he said. My father, replied to him.
Objection,
Did it?
hearsay.
I'm not sure what he was planning to say, but I don't know what he's going to say.
Yes, Your Honor, if I could be heard outside the presence of the jury. I believe the witness just testified. My father said the question called for hearsay. The statement that he's about to elicit is a hearsay statement.
Well, without knowing what it was, could you have an offer of proof so that we know what the statement was going to be?
Yes, Your Honor. I believe the statement was going to be, did you think I needed a prop-up?
And is that statement going to be offered for the truth?
Your Honor, I couldn't tell you what the truth of that statement was. I don't think that makes an assertion. It's a question offered to Dr. Martin at that time. There's no truth being asserted in that statement as far as I can discern.
Your Honor, may I respond?
Well, I'm having trouble, counsel, having some understanding of why the mere fact that something is uttered makes it hearsay. This was a witness to the statement being uttered, and it's not being offered for the truth. Why is it hearsay?
Well, Your Honor, it's our opinion that this question, did you really think I needed a prop up, would in fact be offered for the truth. There's assertion within it. The word prop up is being used to show that Mr. Kittner had just received an injection of propofol. That is in fact an assertion, and it would be offered for the truth of the matter.
Well, I'm going to overrule the objection, really, but I can't parse out.
Yes, Your Honor.
Mr. Kittner, I think you started to say that your father was saying something to Dr. Martin. What did he say?
Yeah, he said, do you really think I needed a prop-up?
Now, did Dr. Martin ever do anything to indicate that he saw you at any point during this exchange?
He did nothing to indicate that he knew I was there. In fact, when he turned away, threw up his hands after my father asked his question, he saw me, and I know he saw me because he asked me, how long have you been standing there?
And Mr. Kittner, after the defendant asked you how long that you've been standing there, what did he do?
Walked away. Left.
You say he left. You mean he actually left your father's bedroom at that time?
Yes.
Now, were you still there watching what was happening with your father?
I was.
So what was happening?
My dad got white as a ghost. I mean, just white in the face. He started seizing, convulsing, shaking. I was scared to death.
Just so we're clear, how much time had elapsed between the injection that Dr. Martin gave your father to the time when you saw your father's appearance begin to change?
It was almost immediate. It was the doctor did it, got up, left, said what he said to me, was gone. I turn around, and that's, my dad's dying.
What did you do?
I immediately screamed for the doctor. I run out, calling for him to come back.
Did Dr. Martin come back?
Not right away, no.
Did he eventually return to that room?
It took him several minutes, but he eventually came back.
What happened when he came back?
He comes back, he's frantic, he's going through his bag. He gives my father another injection at that point.
Did you see what happened after Dr. Martin gave your father that second injection?
Yeah, the seizure stopped. And his breathing stopped. He goes from white to gray. He was basically dying.
Did Dr. Martin do anything else to try to help your father at that point?
No.
What did he do?
He
Objection,
left.
relevance.
He left the room, disappeared.
Now, after you saw your father change color again, did you do anything?
Ran to my room, what we call the playroom, where I was playing video games. I left my cell phone there. I run, call the ambulance, just wait for them to arrive.
Did the ambulance come?
It did.
Now, did you see whether anyone actually tried to revive your father once the ambulance arrived?
The EMTs tried. They tried to resuscitate him. It was obviously way too late.
Were you watching the EMTs while they were trying to resuscitate your father?
Yeah, I was looking for any sign of life, any hope, just hoping he would come back.
Did you see whether or not the EMTs injected anything in your father?
No, they did not.
Thank you, Mr. Kittner. I pass the witness, Your Honor.
Yes, Your Honor. David, do you mind if I call you David?
Sure, that's fine.
David, I want to ask you a little bit about you and your father. You said he was a musician, right?
A great musician.
A great musician, and he was pretty famous, correct?
He was.
He traveled to promote his music?
Sure he did. He was gone a little bit when I was younger, yes.
So when you were younger, he was gone on tour a lot, right?
Yes.
For weeks at a time?
You know, he would come back and see me play ball, do the sorts of things that normal kids do. Try to teach me to shoot out on the ski range. Can't say that I ever looked up butcher cattle or slaughter cattle, but he would come see me often.
Well, David, without getting into all the different times that your father saw you, there were quite a few times when he was gone when you were growing up, weren't there?
Well, yeah, he was on the road.
He was on the road, and during those times, you lived at the house that you two shared, right?
Yes.
Without him.
Yeah, I mean, he was, again, you gotta understand, my dad cared a lot for me. And it wasn't like he would be gone and never in my mind. I mean, we got cell phones, we've got Skype, we were able to keep in communication.
I'm sorry to interrupt you. I understand your father cared very much for you. I'm just asking you, during the times that he was on the road, you were without him, correct?
Yeah, when he wasn't there, I was obviously not with him, yes.
Now, on May 9th, 2011, that was the day when your father was home, right?
Yes.
And you heard him ranting that day?
Yes.
Ranting about pain medication?
Yes.
And you saw his doctor come into the room?
No, I did not.
You saw his doctor in the room, I'm sorry.
Yeah, the doctor was already there injecting him when I arrived in the room.
So you saw Dr. Martin in the master bedroom with your father?
I did.
And after a few minutes, you saw Dr. Martin leave the room, right?
Yes.
And he left something behind, correct?
Yeah, he left, yes, it's a bottle behind that I found in the bed.
Well, before we get to that, he left behind his medicine bag, didn't he?
I don't recall if he did or not.
Okay, well, when he came back, the medicine bag was right there for him to look through, as you testified on direct, right?
He was going through it. I don't recall, honestly, if he brought it back in with him or if he had left it there.
Well, for the several minutes that he was gone, you were alone with your father, right?
Yes.
Now, during the time that you were alone with your father, it was just the two of you, and you felt he was in distress, right?
Yeah, and you got to keep in mind, I wasn't with him the entire time. I'm calling for the doctor to come back for a good deal of time. I needed help for my father, and he was in distress.
Your Honor, I'm sorry. I would have just objected to the narrative and asked you to please instruct the witness to answer the question. Yes, Your Honor, I understand. I'll adjust. Thank you. David, going to your relationship with your father, you sought his approval, right?
I guess as any son does, I wanted my dad to be proud of me.
So as any son, oh, I'm sorry, go ahead.
I'm finished.
As any son does, you sought your father's approval.
I guess, yeah. I wanted him to be happy with me.
You cared for your father.
Absolutely.
And as you just stated, you wanted him to be happy with you.
Yeah.
Now, you'd sought his approval in the past, right?
I can't think of any event that I thought to myself, I need my dad's approval. Am I like every kid and wanted dad to be happy with me? Sure. Was he happy with me? Absolutely.
Well, in the past, he'd let you know when he was happy with you, wouldn't he?
Well, sure he did.
He would tell you so.
Yeah.
And that day, when you were alone with him in the master bedroom, he said to you what he always said when he approved of something.
Objection, Your Honor. Hearsay.
Your Honor, may I respond outside the presence of the jury? I anticipate if the witness is allowed to testify, he will state that his father said to him, "Rock on, little kid," while they were alone in the room together. The statement is not hearsay. It couldn't possibly be offered for the truth of the matter asserted, namely that little kid needed to rock on. That couldn't be offered for the truth. It doesn't meet the threshold definition of
May I respond briefly, Your Honor? Counsel just spent 6 or 7 questions laying what she believes the meaning of that statement to be. Now she's offering it to show exactly what she just laid the foundation, that it means a very specific thing, that Mr. Kittner Sr. was happy with Mr. Kittner Jr. She's offering this statement as an assertion of the truth.
Your Honor, may I respond?
You don't need to do this, counsel, I'm going to rule for you, but I want the officers to understand. She's laid the foundation that this witness can tell us what it means, rather than the statement. All she now listening is the statement that was said that's not understood. So,
Yes, Your Honor.
David, that day your father said to you what he always said to you when he approved of something you'd done, didn't he?
Last thing he ever said to me.
He said, "Rock on, little kid," right?
He said, "Rock on. Rock on, little kid."
And by little kid, he referred to you, correct? Now, David, I want to ask you about when the EMTs arrived. You stated that that day you saw your father stop breathing on his bed, right?
I did.
And you called for help.
Desperately.
You called 911 immediately.
As soon as I got to my phone, yes.
And the ambulance came fast, right?
About 3 minutes.
3 minutes later. And when they got there, they moved fast too, didn't they?
I don't know how fast they moved in relation to other EMTs, but I have no complaints about what they tried to do, if that's what you're asking.
Well, let me ask you, they went straight to your father, didn't they?
Sure they did.
You probably showed him where he was?
I don't recall if I told the 911 operator that we were in the bedroom. I don't remember if I let him I know I stayed with my father, so they just came in. They knew.
So when they came in, they went straight to your father, is that right?
Yes.
And they began trying to save his life. Is that a yes?
Yes.
And they were doing what EMTs do, right?
Not an EMT, but yeah, it looked just like on TV. They were doing everything they could.
Things like CPR, right?
They were doing everything they could to resuscitate him. I don't know CPR.
I understand.
I guarantee that I wish that I had.
I understand. I know this is very painful for you. And you watched them do a lot of things that you probably didn't understand what they were, right?
I did.
Because you were only 17.
Yes.
You just knew they were trying to save his life.
Yes.
There were multiple EMTs, right?
There were more than one.
And they brought equipment?
I don't recall seeing a whole lot of equipment. I think they probably brought in one of those boards that they have. They didn't use it. But as far as equipment, sure, I recall some bags, but I can't tell you exactly what the equipment was or what they had with them.
Well, when they came, as they were trying to save his life, you wanted them to save his life, right?
Who wouldn't?
You didn't want to get in their way, right?
No.
You gave them space?
I don't know that I gave him space. I wanted to stay close to my father. I wanted him to be okay. I was there.
You certainly didn't interfere with them trying to...
Did I stop him? No.
David, I just want to go through a few last things with you. Earlier you testified that your father received the first injection while he was laying on his bed, right?
Yes.
And that after he received that injection, he started suffering seizures and convulsions on his bed, right?
Yes.
And then you testified that he got a second injection while lying on his bed, right?
Yes.
And that after he got that second injection, he stopped breathing on his bed, right?
He did.
Your Honor, permission to publish to the jury exhibit number 5, it's already in evidence, in the form of an enlargement.
No objection, Your Honor.
David, that day your father wasn't found on his bed, was he?
They must have moved him to his chair.
I apologize, David, but you're aware he was found in his chair, right?
That's where he is in that picture. Dead. I still see his face today.
Thank you, David. Nothing further, Your Honor.
Yes, Your Honor. Mr. Kittner, early on in her cross-examination, you said something to counsel about a pill bottle. She said she'd come back to it, but I don't think she ever did. Can you tell us about that pill bottle?
Yeah, there was a pill bottle there on the bed where my father was.
What color was that pill bottle?
It was like any pill bottle you see. I think it had a white cap, a yellowish orange. It wasn't really opaque, but you could see through it and see that there were pills inside of it.
Had you ever seen that pill bottle before that day?
No.
And was there anything specifically that that pill bottle was next to when you saw it on the bed?
It was, my recollection is that's where the bag had been. I don't remember if the bag was still there when I saw the pill bottle or if that was after it had already been taken away by the doctor.
When you say the bag, do you mean the defendant's medical bag?
Yes, Dr. Martin's bag.
Nothing further.
Thank you. I'll try.
Your Honor, the people call Dr. Chris Jensen. Dr. Jensen, please introduce yourself to the jury.
Yes, my name is Dr. Chris Jensen.
What kind of doctor are you, Dr. Jensen?
I'm a pathologist.
What is pathology?
Pathology is basically, I'm a medical examiner. I perform autopsies, determine cause of death.
How are you involved in this case?
I was asked by the state of Lone Star to perform the autopsy on Mr. David Kittner.
Did you receive any kind of training in order to perform autopsies?
Yes, I did.
Could you tell us a little bit about that?
Yes, I went to Johns Hopkins for medical school where I graduated with honors. And then I proceeded to do my residency in Arizona in pathology.
Where have you been practicing medicine, doctor?
Right in Cheapside, Lone Star.
Now you said that you performed the autopsy on Mr. Kittner. Were you able to verify that the body you performed the autopsy on was actually David Kittner?
Yes, I was, and it was David Kittner.
Can you tell us how you began your examination?
Well, first I did an examination of the extremities of outside of the body. I checked, the weight, everything, to sort of just check everything outside.
What did you find?
I found that he was 65 years old, slightly overweight, looked older than 65.
What do you mean he looked older than 65?
Well, I think we've discussed this, but he lived kind of a rock and roll lifestyle, and so I would say it aged him a little bit.
Did your autopsy consist of anything besides the examination of the body?
Yes, I performed a toxicology test, and I also did a dissection of the heart, as well as, observed his other organs.
What toxicology test did you do?
I performed a test on the blood.
Were there other toxicology tests performed to your knowledge?
Yes, there were.
And based on the results of those tests and your examination, were you able to make any kinds of conclusions about Mr. Kittner's body?
Yes, I was.
What was your conclusion?
I found that he had a number of drugs in his system, which led to a massive heart attack, which resulted in his death.
Were you able to determine cause of death to a reasonable degree of scientific certainty?
Yes, I was.
You said that there was a heart attack. Can you tell us how that could have happened?
Well, as I said, there were a number of drugs in his system. Propofol, adrenaline, and hydrocodone were the three main drugs that I believe caused this massive heart attack that caused his death.
Okay, so let's talk about each of those three drugs separately.
Certainly.
You said propofol. What's propofol?
Well, propofol is a sedative and anesthetic. It's used frequently in surgery to anesthetize the patient.
Do you yourself prescribe propofol?
I do not.
Why not?
I am a pathologist. I generally don't prescribe medications. I also am not an anesthesiologist. Those are the people that should be using propofol and prescribing propofol.
What kind of setting should propofol be prescribed in?
A hospital setting, because propofol when you're administering propofol, it really requires that you have a lot of equipment with you so that if something goes wrong, you have the necessary equipment for, to open up airways, etc., to make sure that the patient stays alive.
What background information were you able to review on Mr. Kittner besides the examination of his body?
I was able to review some medical records.
Within those medical records, was there anything at all to indicate he had a condition that required propofol?
No, there was not.
What, if any, prescriptions for propofol did you find in his medical records?
I found 0.
So let's talk about that second drug that you mentioned. That was hydrocodone. What's that?
That is a pain medication. Vicodin is another name for it.
You said it's a pain medication. Does it have any side effects?
No, not really.
Does it combine with other drugs in any way?
Yeah, definitely there could be very fatal and dangerous drug interactions, and propofol is one of those drugs that should not be combined with hydrocodone.
What happens if you combine hydrocodone and propofol?
It can tend to cause a massive heart attack.
Now, the third drug you mentioned was adrenaline. What's adrenaline?
Adrenaline is often used to resuscitate people who are having a heart attack. So you might have seen on TV before somebody's having a heart attack and they just stick a syringe right in their heart, and that helps start their heart up again.
Now, correct me if I'm wrong, doctor, but do we all have adrenaline in our bodies?
Yes, we do.
So why was it significant that you found adrenaline in Mr. Kittner's body?
Well, these are much higher levels of adrenaline than you would expect from just the adrenaline produced in our body, and it implied to me that there had definitely been an injection of adrenaline.
And what, if any, interaction does adrenaline have with the other two medicines that you mentioned?
The three of those medicines together can basically explode a heart.
Now, Dr. Jensen, I'd like to ask you a few hypothetical questions. Now, if you were a doctor treating a drug addict, would it be reasonable to give that patient propofol?
Objection, relevance. Let me be heard. As to what is a reasonable, and additionally as to a hypothetical situation. Your Honor.
Yes, Your Honor. One of the things that the state has to prove today is that Dr. Martin acted recklessly. Now, I understand that I'm using the word reasonable. I can rephrase the question, but what I'm asking Dr. Jensen to do is talk about the standard medical practice. I'm happy to rephrase and use that language, but this testimony certainly goes to our burden to prove the mental state of the defendant.
May I respond?
I'm inclined to agree with you, counsel, but I'm having some trouble with the lack of predicated and hypothetical. I think you could ask the questions so it gets closer to the facts of this case.
Yes, Your Honor.
Your Honor, so may I briefly respond? I believe it would be an improper opinion for this witness to testify as to what I anticipate would be an opinion as to what is a gross deviation from a standard of conduct. This witness has testified that she has a limited amount of experience in just determining cause of death. She said, in fact, earlier that she's never administered propofol. She has no idea how to administer propofol. She doesn't do it in her practice. For her to testify that administering propofol in a certain situation would then be unreasonable or a gross deviation goes outside this witness's expertise.
That seems a fair comment to me.
May I respond, Your Honor?
Yes.
We've actually laid the foundation with Dr. Jensen that she knows what propofol is, knows how it's used, and knows where it should be used. Just because she's not an anesthesiologist doesn't mean that she can't talk about the proper medical treatment involved with propofol. Not every doctor is going to prescribe every medicine. She's still allowed to testify based on her experience as a doctor what would be proper care.
And Ms. Truman, I might agree with you if I had heard her do the things you say she's done. Maybe I just wasn't paying attention. Perhaps you can lay some foundation that she understands what the treating standard of care should be.
Absolutely, Your Honor. Dr. Jensen, if we could just back up to talk about propofol again, how do you know what propofol is?
Because I went to medical school and I am a doctor and I am very well aware of what the drug is.
Have you read any articles or treaties on propofol?
Yes, the physician's desk reference is one of those, and because of that, again, I am very familiar with what propofol is.
And where, if anywhere, did you learn about proper care associated with propofol?
Again, the physician's desk reference discusses the proper care that goes along with administering propofol.
Are you familiar with David Kittner's background?
Yes, I am.
What, if any, information did you have about him being a drug addict?
It was well known that he had battled with drugs for most of his life.
Do you know what drug specifically he battled with?
Cocaine, Big C, yayo, booger sugar, cocaine.
Thank you, Dr. Jensen. Now, if we could talk about specifically administering propofol to a drug addict, would that be proper, and if not, tell us why not?
It would not be proper because, again, if a drug addict, even if perhaps, let's say they've said that they've quit, they have a history of drug use, and it's hard to say if there might be other drugs in their system, so you would not want to administer propofol because of the dangerous interactions that I discussed previously.
And is it in accordance with standard medical practice to prescribe propofol in a home setting?
No, it is not.
Why not?
Because as I discussed earlier, there is certain medical equipment that you need to have on hand when administering propofol, which you would not have in a home setting.
Is it proper medical practice to administer adrenaline after a patient's been given propofol?
Not at all.
Why not?
Because the combination, again, can cause a massive heart attack. It's contraindicated, which just means they should not be given at the same time.
Thank you, Dr. Jensen. I pass the witness.
Cross, Your Honor. Thank you. Dr. Jensen, you just testified that Mr. Kittner's heart attack was caused by hydrocodone, propofol, and adrenaline, right?
Correct.
And you gave a deposition in this case, didn't you?
Yes, I did.
At that deposition, you were asked questions?
Yes, I was.
And you gave answers?
Yes, I did.
Truthful answers?
Correct.
Because you were under an oath?
Correct.
An oath to tell the truth?
Yes.
The same oath you took before you testified in front of the members of the jury here today?
Yes.
At that deposition, you were asked this question, you gave this answer. Counsel, page 17 of the record, lines 7 to 10. Question, in your professional opinion, would a reasonably prudent medical doctor inject propofol into a patient who had been using hydrocodone? Answer, absolutely not. Injecting propofol into a patient who was using hydrocodone is reasonably calculated to and did here cause the fatal cardiac event. You were asked that question, you gave that answer.
Objection, hearsay, Your Honor, this is an improper impeachment. Because as it stands, as of right now, opposing counsel has read out-of-court statements into the record, and at this time, yes, of this witness. Yes, Your Honor, this, no contradiction has been shown by opposing counsel, so at this point in time, this impeachment is improper.
May I respond? Yes, Your Honor. Now, you're familiar with the physician's desk reference, as you testified to.
Correct.
Widely relied upon by doctors, right?
Yes.
It has a lot of information about drugs in it,
Correct.
how to use drugs.
Correct.
Specifically, there's a section on propofol
Yes, there is.
and how to use propofol.
Yes.
And the section of the PDR talks about how propofol interacts with other drugs.
Sure, yes.
Specifically, there's a section on how it interacts with hydrocodone.
Correct.
Now, you said earlier that you should never mix these two drugs, right?
Correct.
Because they cause heart attacks, in your opinion.
Yes, they can cause heart attacks.
The PDR states that the induction dose requirements of Propofol X injectable must be reduced in patients with oral intravenous premedication, right?
Can I please have a copy of what
Absolutely.
you're
May I approach the witness, Your Honor?
Thank you.
Let the record reflect that I'm showing the witness what we'll mark as a defense exhibit 6 for identification. It's the PDR. Under the section called drug interactions, just as a general matter, it says that the induction dose requirements of Propofol X injectable must be reduced in patients with oral or intravenous premedication.
Yes.
Right? And so it says that when you're administering propofol to someone on, say, hydrocodone, the dose of propofol just must be reduced, right?
It says it must be reduced, correct.
In fact, so this essentially gives you instructions on how to administer propofol with hydrocodone.
Correct.
It doesn't say that hydrocodone and propofol cause heart attacks, does it?
It still can cause heart attacks. Here it says it must be reduced, correct.
Well, it doesn't say here that it causes heart attacks, though, right?
Correct, it says it must be reduced.
And it says that the mix of these two drugs may elevate cardiac stress.
Correct.
Obesity elevates cardiac stress,
Sure.
elevates the risk of a cardiac event, like a heart attack.
Sure.
So does drug use,
Correct.
stressful lifestyle,
Correct.
or rock and roll lifestyle.
Sure.
Now, you're a pathologist.
Yes, I am.
You studied Mr. Kidner's body after he unfortunately passed away.
Yes, it was very unfortunate.
Weren't able to observe him when he was alive.
No, I was not.
You didn't have a chance to see his symptoms,
No, I did not.
or when his symptoms started.
Correct.
You examined Mr. Kidner's heart,
Yes, it did.
and that showed you that he had a heart attack.
Correct, in conjunction with the rest of my autopsy.
But your examination of the heart, that didn't tell you when the heart attack occurred.
Well, I'm pretty certain it occurred that day.
Right, but it didn't tell you when precisely on May 9th it occurred, to be fair.
No, I do not know the exact moment that the heart stopped.
Okay. Now, as part of your examinations, you reviewed some records, right?
Yes, I did.
And conducted some tests.
Correct.
You conducted a toxicology test.
Yes, I did.
I want to talk to you about what was found in that toxicology test.
Certainly.
You found cocaine in Mr. Kidner's system.
Correct.
Cocaine elevates the risk of a heart attack.
Sure.
Cocaine's a stimulant.
Yes, it is.
You found ketamine in Mr. Kidner's system.
Yes, I did.
Ketamine.
Trace amounts.
You found ketamine in Mr. Kidner's system.
Yes, I found trace amounts of it.
But it was in his system, right?
Correct.
And that's a depressant.
I am not entirely certain what ketamine does. I did not look into that because it was such small amounts.
Okay, so fair to say you didn't look into what that substance does to the body, as you just said.
Sure.
You found sodium hydroxide and aluminum powder.
Yes, trace amounts.
You found those two substances in his system, though.
Yes, and trace
You found,
amounts.
found hydrocodone
Yes, I did.
as Vicodin.
Correct.
But that test didn't tell you how much Vicodin that Mr. Kidner had taken that day.
Did not tell me the exact amounts, no.
In fact, as we sit here today, we have no idea how much Vicodin he consumed on May 9th.
We do not know, but we know that it was enough to interact with propofol and adrenaline to cause a massive heart attack.
So it's fair to say we have no idea how much Vicodin he took that
We
day.
do not know the exact amounts.
You conducted an autopsy, as you spoke about.
Correct.
Part of that autopsy involved making physical observations of Mr. Kidner's body.
Correct.
You make those observations in every autopsy,
Yes, I do.
because those observations can help you determine cause of death.
Yes,
In this case, Mr. Kidner's death was caused by a heart attack.
that is correct.
And you made some observations in an effort to try to figure out the cause of death in this case.
Yes.
And you noticed and you observed and knew that Mr. Kidner was 65 years old.
Yes, he was.
He was 224 pounds.
Yes.
But he's only 5'9".
Okay, yes.
Right?
Sure.
That made him medically obese.
Yes, he was overweight.
You mentioned that he looked a little older than 65,
Yes, he did.
and you had a reason why.
Yes, as I said, he had battled drugs for a long time and had a rock and roll lifestyle, so it aged him.
Right, it had done damage to his body.
Sure.
Then you mentioned that you attributed this to his drug use.
I just mentioned that it was based on his lifestyle, yes.
A lifestyle that increases the risk of cardiac stress.
Sure.
You reviewed some medical records of Mr. Kittner as well.
I did.
Specifically, you reviewed a record from a place called the Golden Dock Healthcare Clinic. I have a copy if you'd like one.
Oh, please.
I'll let the record reflect I'm showing the witness old marked defense exhibit 4 for identifications, the record from the Golden Dock Health Clinic. Now, this is a record you reviewed in determining cause of death, right, Dr. Jensen?
Yes, it is.
You learned some information from this record, right?
Sure.
Specifically, you learned why he was coming to see a doctor on this day, right?
Yes, what he wrote down.
And this record is from April 21st, 2011.
Yes, it is.
About 18 days before his death. About 18 days before his death, he's experiencing difficulty breathing.
That's what's on this page, yes.
He had been experiencing it for 48 hours.
Yes.
He talks about when this problem started. Right?
Yeah.
He just says, having a beer with some friends, and I started having trouble breathing.
Is that a question?
Yes.
Yes, that is what it says.
You also have a portion of the testimony, or a portion of the document that asks if he suffers from or has any family history of certain symptoms. Right?
Yes.
He answers yes to dizziness. Right?
Is that a question? Yes.
Yes to fainting spells, correct?
Yes.
And these are responses to the question, do you suffer from or have any family history of these symptoms? Right?
Yes.
And we can tell from that document that he had difficulty breathing just a little more than 2 weeks after his death, or before his death.
Is that a question?
He had difficulty breathing 2 weeks before his death, right?
Yes, that is what this says.
You weren't there on May 9th, that's fair to say.
I was not there, correct.
You did not see Dr. Martin.
I did not see Dr. Martin there.
You didn't see Mr. Kittner.
I was not there, so no, I did not.
You didn't see Mr. Kittner Jr.
I was not there, correct.
The toxicology test had told you that hydrocodone was in Mr. Kittner's system,
Yes, it did.
but it didn't tell you when it was given to him
No, it did not.
or who gave it to him.
No.
You found adrenaline in Mr. Kittner's system,
Yes, I did.
but that didn't tell you who gave it to him
No, it did not.
or when it was administered.
No.
You found propofol in Mr. Kittner's system,
Correct.
but not when it was given
Correct.
or who gave it to him.
Correct.
But you did find it in 3 times the medical amount.
Exactly, which shows that it had to have been given very close to the time of his death for it to still be in his system at those levels.
Okay, well, I'm just asking, you found it in 3 times the medical amount.
Correct.
You know that doctors have training on how to administer medications in general.
Correct, some of them do, yes.
And syringes, they have markings on the outside of them to show the dosages.
Sure.
Doctors are trained to look at that and know how much is in the syringe, right?
Yes.
And they're trained to administer a dose based on the amount in the syringe, right?
Question? Yes.
And you know Mr. Kittner was not a doctor.
No, he was not.
You wouldn't expect a 16-year-old to know that kind of information, right?
No, I would not.
In your autopsy report, you summarized your opinion, right?
Yes, I did.
In that document, you used the term decedent.
Could you please provide me a copy of
Oh,
that?
sure.
Thank you.
I believe this is entered into evidence, State's Exhibit 3. Under the subject of opinion, you use the term decedent, right?
That is used there, yes.
Decedent, you mean David Kittner Jr. I'm sorry, David Kittner Sr., my apologies.
Yes.
And in that opinion, you contain an opinion as to who injected the propofol that day.
Well, as you just discussed with me at length, I was not there that day, so I wasn't there to see who did it. All I know is he was injected with propofol as well as adrenaline, and he had hydrocodone in his system, so in my opinion, as I have stated here, that caused massive cardiac arrest.
Well, as to cut to the heart of the matter here, you state in your autopsy report, the decedent apparently injected propofol in the presence of hydrocodone.
Correct, that is what that says.
Thank you. Nothing further, Your Honor.
Very briefly, Your Honor. Okay, I'll do my best to keep it short, Your Honor. Dr. Jensen, I'd like to pick up right where opposing counsel left off. Do you still have your autopsy report up there?
Yes, I do.
He read you a sentence about the decedent injecting propofol in the presence of hydrocodone. Could you actually just read the next sentence on your autopsy report?
Yes, as I was discussing, the resulting symptoms were treated by injection of adrenaline, which produced a massive cardiac arrest episode leading to death.
Now it says treated by injection of adrenaline there. Do you know who treated him with adrenaline?
I do not.
Could you tell who administered any of the injections in this case?
No, I could not.
Now, opposing counsel also asked you about shortness of breath and various other side effects. Would you prescribe propofol for shortness of breath?
Objection, relevance.
No, I would not.
Why not?
Because it is not used for that purpose.
Your Honor, permission to approach the witness? I promise I'm almost done. Dr. Jensen, what did I just hand you?
This is my deposition.
If you could just turn to the last page of the deposition. Opposing counsel asked you about propofol and hydrocodone. Now, you asked a question on the last page about what your opinion is based on in this case.
Yes.
If you could just read that last answer out loud, please.
Okay. It is based on the fact that the particular medication is absolutely contraindicated for any patient who is known to be on propofol and hydrocodone. The combination of those things will just absolutely explode the heart. In fact, given the hydrocodone, propofol, and adrenaline, I'm surprised I could even find the heart during the autopsy.
So how many drugs led you to your conclusion today?
3.
Thank you, Dr. Jensen. No further questions, Your Honor.
All right, we're going to take a 10-minute recess while we are on recess.
Yes, sir.
I appreciate it. If you haven't done so already, consult with counsel and see what
Yes, sir.
Your Honor, at this time, we would ask to read portions of the deposition testimony of Bree Trevino, pursuant to the stipulation that she's unavailable, and we'd like to proceed by professional statement having my co-counsel take the stand. We understand that counsel does have one objection to one line or 2 lines in this statement. I'm not sure what that objection is yet, but if we'd like, we can take it up now.
Well, I think we should out of the presence of the jury so that we can just do it smoothly when we bring the jury in. What's the objection, Mr. Vittori?
Your Honor, the testimony of Bree Trevino will allege that she was with Dr. Martin on the day in question and was sharing a few laughs and a joint. Firstly, it doesn't establish when at all this joint was being smoked. But more importantly, again, this goes to the charge in this case, and namely to recklessness. Smoking a joint is not, under Your Honor's instructions, go towards recklessness at all, unless the state can tie it up with the fact that that factored into his decision to administer propofol or adrenaline on May 9th. It's irrelevant and it's prejudicial. His acts, other than administering the propofol and adrenaline, cannot be considered towards recklessness in this case, and so we would move to exclude that portion of evidence.
State?
Yes, sir. I'm unsure if counsel's objecting to character or relevance, but either way, this is admissible testimony. Now, we're not offering the fact that he was smoking marijuana to prove action and conformity therewith or something like that. We're using it to show what his mental capacity was when he was making these decisions. And it's certainly relevant what his mental capacity was when he's acting as a physician and trying to give medical care to his patient. I think we would all want to know if our doctors were smoking marijuana before they came into the room to see us, and that's because we want to know if they were acting recklessly. This testimony, we believe, is admissible.
I confess, Ms. Tuminelli, that I'm confused about the difference now between negligence and recklessness. If he's impaired, doesn't that go to negligence rather than recklessness?
Your Honor, I think that it can absolutely go to both mental states. Now, in order to consciously...
But negligence is not a mental state that's relevant to this trial. Only recklessness is. So how does being impaired go to recklessness?
Absolutely, Your Honor, because we have to show that Dr. Martin knew of a risk and consciously disregarded that risk. So in order for him to know of the risk and be conscious of it and consciously disregard it, he has to have all of his wits about him, and he has to be, or if he doesn't have his wits about him, that would certainly be relevant as well. But if we have to show that he knew of a risk, he was thinking about it, it would certainly be relevant that he was smoking marijuana, which we know is a mind-altering substance, right before he's consciously disregarding that risk.
Respond.
You may.
Your Honor, I respectfully disagree with the interpretation of that instruction. Again, it's a reckless act. This isn't an impairment or a negligent case. To offer evidence of this impairment goes directly to negligence, which is not the mental state at issue. It has to be a reckless act that disregards a substantial risk, not a reckless state of mind where one is likely to disregard a risk. It has to be an act that disregards that risk. Smoking marijuana is not an act that disregards the risk of killing Mr. Kittner.
Well, could it be reckless to smoke a joint and then proceed to give medication?
Not in this case, Your Honor, because that would go to negligence. In this case, the only reckless acts that are charged and must be assessed by the jury are the acts of allegedly administering this medication. Those are the acts at issue. Any impairment or failures aside from that act go to negligence and are not relevant in today's case and are unduly prejudicial to Dr. Martin.
May I respond to that, Your Honor?
Yes.
If opposing counsel's objection is to relevance, relevance is a minimal scintilla standard, Your Honor. We are certainly far and above the scintilla standard of relevance at this point in time. It's relevant what Dr. Martin was consuming right before he administered what we believe was a shot of propofol and adrenaline on May 9th, 2011. Now, if opposing counsel has another objection, I'm happy to respond to that, but if the objection is relevance, we have certainly showed that this testimony is relevant.
All right, well, I'm inclined to allow the statement to come in. I will tell the state that I have some concern that you may be shooting yourself in the foot when this case gets to the Court of Appeals, but if you choose to pull that trigger, that's on you.
Yes, Your Honor.
Your Honor, at this time, can we assume that you've instructed the jury about what's about to happen, the procedure?
Yes, this is a very, very sophisticated jury.
Would you please state your name for the record?
My name is Bree Trevino.
Where do you currently reside?
Loyola-Chicago Star.
How long have you lived there?
Since special pay bid test.
And before that?
At the Kittner Mansion in Arkansas.
How long did you live there?
Which time? I mean, I was there some years ago when I was dating David, and then I came back and was living there when he met his unfortunate death.
As his girlfriend?
No, that was then, but it's all over now. He hired me to be in charge of maintaining equipment in his private recording studio and maintaining the other audio equipment around the mansion.
Turning your attention to the next page, line 6. Did you ever observe Kittner to be intoxicated in the last 6 weeks of his life?
Kittner intoxicated? What a surprise that would be. Yes, I saw him wandering around the big house holding bottles of vodka or bourbon or wine just about every day, just about every time of day.
Did you actually observe him drinking any alcohol in the last 6 weeks of his life?
No, I never actually saw him swigging the stuff.
Did you ever observe Kittner taking what you knew to be drugs during the last 6 weeks of his life?
I saw him in his master bedroom on a couple of occasions during that time when he had a white, powdery substance in a baggie in his hand, smiling that dopey smile he got when he was high.
When was the last time you saw David Kittner wandering around with a white, powdery substance in his hands?
The day before he died.
What was the occasion?
I was fixing a speaker in his bedroom. It had blown out because he had turned the volume up too high. I went into the bedroom and he was sitting in his favorite red chair, grinning ear to ear, white stuff in a baggie on the bed.
Did you actually see Mr. Kittner take or consume cocaine at any time during the last 6 weeks of his life?
No, I never actually saw him ingest any cocaine during the last 6 weeks of his life.
Did you see David Kittner take any other medications in the 6 weeks before his death?
I didn't actually observe Special K taking any of this, but I did hear a conversation between Dr. John and David about needing some pain medication to help with some chronic pain caused by an old injury.
What kind of old injury?
It was a guitar string injury, as I recall.
Moving down to line 17. Were you at the mansion the day Mr. Kittner died?
Yes, I was out at the cabana on the far side of the estate.
What were you doing?
I was hanging out with Dr. Martin. Dr. John, as he liked to be called. We were sharing a few laughs and a joint.
Did anything unusual happen that day?
You mean other than Kittner croaking? Yes, Dr. John got a call from David. David was shouting and I could hear his voice even though I was sitting a few inches away. David demanded that Dr. John come over to the mansion immediately. David said he was in some sort of pain or distress or something. He said something about not being able to breathe, which is what he said when he kicked me out of the mansion the first time, so I didn't take it too seriously, but Dr. John did.
What happened then?
Dr. John hung up and started gathering up his medical bag. He turned to me and said, "I'm gonna go fix him once and for all." And then he ran out of the cabana.
What was the next thing you saw her?
Dr. John came back to the cabana about 15 minutes later. He told me he had fixed the problem.
Then what?
Well, that joint wasn't quite gone yet. So, and to tell you the truth, we've been celebrating our engagement that day, so the dead guy thing was kind of a downer.
This concludes the portions that we intend to read, Your Honor.
All right. Is there anything further on this?
No, not from the defense, Your Honor.
All right. Does the state have anything further?
Yes, Your Honor. At this time, we would offer what's been pre-marked as Exhibit 12. Exhibit 12 is an email sent between two individuals. We are offering it pursuant to a stipulation that it is what it purports to be, which is an email between a member of the Old Star Entertainment Group, LLC, and the defendant, Dr. John Martin.
Any objection?
Well, Your Honor, we would prefer the actual foundation be laid for the email. We do intend to call the defendant here today and lay proper foundation, enter the document properly through the defendant, to enter it now without foundation.
So I take it that means you don't object.
I don't, no, Your Honor, I don't object.
All right, then the exhibit will be received.
With that, Your Honor, the state rests.
All right. Does the defense have any motions?
Yes, Your Honor. At this time, the defense makes a motion for judgment of acquittal. Even viewing the evidence in the light most favorable to the non-moving party, in this case the state, they have not provided enough evidence for a reasonable jury to find the identity of the person who actually injected that propofol, or to find that the cause of death was truly the propofol and adrenaline in this case. And we move for a judgment of acquittal.
It's the court's view that the state has met its burden to proceed, so your motion is denied. You
Yes,
may
Your Honor.
proceed with your case.
Your Honor, at this time, the defense calls Dr. Leslie Walker to stand. Good afternoon.
Good afternoon.
Can you please tell us your name?
Yes, my name is Dr. Leslie Walker.
And what do you do for a living?
I am a doctor. I'm an MD.
Dr. Walker, can you tell us a little bit about the education you received prior to becoming a physician?
Well, first I went to Yale University for my undergraduate degree, where I received a degree in biology as well as physics. And then after that, I went to Lone Star A&M University.
Did you receive a medical degree at Lone Star A&M?
Yes, I went to medical school at Lone Star A&M.
Now, after you received your dual science degrees and your medical degree, what type of experience did you have in the medical field?
Right after coming from medical school, I decided to volunteer some of my time and give back to the community. So I enrolled in a program called Doctors Without Borders, where I gave medical assistance to underprivileged and malnourished people throughout the earth.
Now, after you volunteered with Doctors Without Borders, what did you do next?
After that, I went to the Mayo Clinic, which I'm sure you all know. It's a well-known, prestigious clinic here in the United States that is on the brink of every technological advance.
Doctor, after your experience with the Mayo Clinic, did you take a position with a clinic or hospital?
Yes, I took a position with a clinic here in Armadillo.
And what types of patients do you see at the clinic in Armadillo?
Well, currently I practice general medicine, so I see a wide range of patients.
Doctor, I want to ask you about how you became involved in this case. Who first contacted you?
Well, I was retained by the defense to evaluate whether or not Dr. Martin had adhered to the professional standards.
Were you also asked to look at the facts surrounding David Kittner's death?
Yes, I looked at all the facts and circumstances surrounding his death.
Dr. Walker, what materials did you review in doing so?
Well, I reviewed all of the depositions, and I reviewed the autopsy report and the toxicology report, and there were also several other articles and medical records that I reviewed.
And did you form an opinion as to the cause of David Kittner's death?
Yes, I did.
Before we get into that opinion, what did you base it on?
Well, I based it off of, like I said, the toxicology report and the autopsy, which said that he suffered from a cardiac arrest.
Did you also base your opinion on your education, training, and experience?
Yes, I based it on my skills, knowledge, education, experience, and training.
And Dr. Walker, is that opinion to a reasonable degree of medical certainty?
Yes.
What is your opinion as to what caused David Kittner's death?
As I said earlier, it was a cardiac arrest.
Doctor, I want to talk to you a little bit about the bases for that opinion. One of the things you stated in your review was the medical records in this case?
Yes.
Now, going off the medical records, what did you discover about Mr. Kittner's physical condition prior to his death?
I discovered that he was an obese man. He was about 5'9", weighed 220 and some change. Wasn't by far nowhere near the peak of his physical capabilities.
And you say he weighed a little over 220 pounds and 5'9". Is that considered medically obese?
Yes.
And does that put someone at risk for a cardiac event?
Absolutely. That's one of the main factors we look at.
Now, what about his eating habits or exercise habits? Did those put him at risk?
Absolutely. We all saw him on the television all the time, and we heard him on the radio, and he was not physically fit. He very rarely exercised, and all of that contributes to heart attack or cardiac arrest.
Dr. Walker, what about Mr. Kittner's lifestyle? Did you learn anything particular about his lifestyle that put him at risk?
Absolutely. Besides my personal observations, there was also indications that he had been a heavy drug abuser. He'd used cocaine. There were also some allegations that he was trying to inject Drano into his bloodstream.
Before we get into that, doctor, just going to the cocaine usage. What does cocaine exactly do to the heart?
Cocaine increases the heart rate, so it makes the heart pump at a very fast rate.
So does long-term cocaine usage, would that damage the heart?
Absolutely. Any sort of abuse on a heart would, over time, definitely lead to cardiac arrest.
And if someone were to abuse cocaine longer, would that then damage the heart even more?
That would definitely be reasonable.
Now, doctor, after reviewing the medical record and seeing all these symptoms, all of these risk factors, did you discover anything in the record to show that Mr. Kittner had in fact suffered symptoms of cardiac stress prior to his death?
There was actually a medical report where he had complained about suffering from shortness of breath about 2 weeks prior to the fatal cardiac arrest.
Counsel, referring to what's been previously marked as Defense Exhibit 4 for identification, Your Honor, may I approach?
Yes, you may.
Would you like a courtesy copy?
No, I have them. Thank you.
Dr. Walker, I'm showing you what's been previously marked as Defense Exhibit 4 for identification. Do you recognize this?
Absolutely.
What is this document?
This was a medical record that I reviewed in coming to my ultimate conclusion.
And is this a fair and accurate depiction of the medical record review?
Yes.
At this time, the defense would move to enter into evidence Defense Exhibit 4, striking all marks of identification.
Any objection?
No objections, Your Honor. I believe it was already entered into evidence, wasn't it?
That's what I thought too, but can't hurt to enter it in twice.
Your Honor, I don't believe it was officially entered into evidence, just want to lay the proper foundation.
Okay.
Dr. Walker, looking at the exhibit in front of you, can you tell us what exactly this is?
This is a medical record from Golden Dog Health Clinic about Mr. Kittner.
And is this something that David Kittner filled out for the purpose of medical treatment?
Yes.
Now, can you tell us whose name is it in the blank that says patient name?
David Kittner.
And what date was this filled out?
April 21st, 2011.
How long is that before Mr. Kittner died?
It's about 2 weeks.
Does it state on here why Mr. Kittner went to go to this clinic?
Yes, it does.
What does it say he was complaining of?
He was having trouble breathing.
Does it say how long he'd been suffering from trouble breathing?
It appears that he he began the symptoms 2 nights prior to coming into the clinic.
Doctor, is there a section on this form that discusses any of Mr. Kittner's medical history?
Yes, there's a whole section in it.
What is that section titled?
Do you suffer from, or is there any family history of?
And does he indicate positively for any of the symptoms listed?
Yes.
Which ones?
He indicates positive for dizziness, fainting spells, and hives.
Doctor, did you find on the record any indication that Mr. Kittner had suffered from any of those symptoms again after his visit to the California clinic?
Yes, after reviewing all the depositions, I learned that David Kittner was suffering from those exact symptoms prior to his death.
Which symptoms exactly was he suffering from prior to his death?
He was having trouble breathing, and I believe there were some chest pains, as well as his palms were very clammy, his pupils, just things of that nature.
And to be clear, what day was he suffering these symptoms?
The day of his death.
Now, doctor, did you have an opportunity to review the autopsy report in this case?
Yes.
Counsel, referring to what's been previously marked as Exhibit 3. Let the record reflect that I'm showing the witness the same document. Dr. Walker, do you recognize this?
Yes, I do.
And is this the autopsy report you relied on in forming your opinion?
Yes.
Now, can you tell us, when you examined this autopsy report, did you discover that there were any drugs in Mr. Kittner's system the day he died?
Yes, there were quite a few drugs in his system.
What drugs were those?
There was propofol, adrenaline, hydrocodone, residual levels of cocaine, THC, ketamine, and sodium hydroxide and aluminum powder.
Now, out of everything you just listed, are any of those medications?
There are 2 of them that are medications.
Which ones?
The propofol and the hydrocodone.
And going to the propofol, what is that exactly?
That is it's a fairly common drug, and it's sometimes used to diagnose. It can be used as a medicine for anywhere from anesthesia to just treating anxiety. It's a sedative.
Okay, so you stated it was used for anesthesia all the way to anxiety.
Yes.
As a sedative, can it be used for those different things in different amounts?
Yes.
Is it ever used for pain medication?
No.
What if it was used in large amounts? Would it then have a pain-reducing effect?
No, it wouldn't have a pain-reducing effect at all. It would actually have a hallucinogenic effect on the person who was taking it.
Did you find in the record anywhere that Mr. Kittner was prescribed propofol?
No, there was no indication in the record that there was a prescription for that.
Did you find any indication that he was prescribed the other medication in his system, Vicodin?
There was a prescription for the hydrocodone in the record.
Counsel, referring to what's been previously marked as Defense Exhibit 9 for identification. Let the record reflect I'm showing the witness the same document. Dr. Walker, do you recognize Defense Exhibit 9 for identification?
Yes.
What is this?
This is the prescription that I reviewed as coming to my ultimate conclusion.
And is this prescription in the same or substantially the same condition it was when you reviewed the medical record?
Yes.
At this time, the defense moves to enter into evidence Defense Exhibit number 9, striking all marks of identification.
Objection here set, Your Honor.
May I respond, Your Honor?
Yes, you may.
Outside the presence of the jury?
Of course.
Your Honor, this is a prescription and it meets exception 807, Rule 807. It is the exception that states that a piece of evidence needs to be, it's the only thing that can prove a material fact, and namely this fits under 807 mostly because it has circumstantial guarantees of reliability and trustworthiness. This is a prescription. It's something that both the general public rely on to be true and also professionals in the medical field rely on to be true. Those are circumstantial guarantees of trustworthiness in this information. Furthermore, the state opened the door in reading in Bree Trevino's testimony that Mr. Kittner had spoken to his doctor 6 weeks prior to his death about receiving pain medication. The fact that Mr. Kittner has a prescription for pain medication right about 2 months before his death from another doctor goes to proving the fact that Dr. Martin refused to give his patient pain medication. It goes to proving a material fact in this case. It's highly relevant, Your Honor, and this is the only evidence we have that would go to prove that fact.
May I respond, Your Honor?
You may.
My objection wasn't to relevance, it was to hearsay. This is an out-of-court statement being offered in court for the truth of the matter asserted. Namely, that this prescription for Vicodin, if I may say outside the presence of the jury, was actually prescribed on March 12, 2011, and that it was refillable 4 times. Now, opposing counsel actually just told us that that's exactly what she's going to be using this prescription to show, that Mr. Kittner had this prescription before he died for hydrocodone for pain medication. That is using it for the truth of the matter asserted, and it's hearsay, Your Honor. We don't have the indicia of reliability that 807 requires.
Your Honor, may I respond briefly?
Yes, you may.
I would be offering this for the truth of the matter asserted. However, it meets an exception, so it wouldn't be hearsay. It meets 807. It has more than indicia of reliability. It has several circumstantial guarantees of trustworthiness in this case, which is exactly what Rule 807 asks for. And usually it's the most difficult element to establish, as a prescription used commonly in the medical field, relied upon not only by professionals but also the general public. It has plenty of circumstantial guarantees of trustworthiness, far more than other evidence would to go to this point. Your Honor, we don't have other evidence that would go to this point to disprove the fact that the state has offered.
Is Dr. Acker unavailable to testify? Is there some reason why we can't go to the horse's mouth on this?
Not to our knowledge, Your Honor.
I'm sorry?
Not to our knowledge. He's not unavailable.
Well, Your Honor, in this jurisdiction, we cannot call Dr. Acker.
So he's beyond the subpoena power?
I'm sorry, Your
He's
Honor?
beyond the subpoena power of this court?
I believe so.
And did I hear correctly or incorrectly that this is a record that was reviewed by this expert witness?
Yes, Your Honor. It is also
Was this record used in formulating any of her opinions?
Yes, Your Honor. It's something this expert witness relied upon in forming her opinion.
And to what opinion does this document go?
This document goes to the fact that David Kittner received Vicodin. It goes to how the Vicodin got into his system. The state has alleged that Dr. Martin was aware that Mr. Kittner had Vicodin in his system. This goes to prove that Mr. Kittner, in fact, sought different physicians to get that Vicodin, that Dr. Martin could not have been aware of that.
This is a tough, close call, and one that I'm sure that the Court of Appeals will want to look at very closely, but I'm going to allow it.
Your Honor, is this admitted substantively?
Well, it's admitted.
Thank you, Your Honor. Dr. Walker, looking at the document in front of you, can you tell us who it's prescribed to?
It is prescribed to David Kittner.
And what is the date that this was prescribed?
March 12, 2011.
About how long was that prior to Mr. Kittner's death?
It was about 2 months prior.
And what is the medication that is prescribed here?
It's Vicodin.
Doctor, how many, if any, refills does this prescription allow for?
It allows 4 refills.
I'm sorry, what number was it?
4 refills.
And does it say what physician prescribed this Vicodin?
It was Dr. Rodney Acker.
Was Dr. Acker Mr. Kittner's physician?
Absolutely not to my knowledge.
Did you discover in the record anything to indicate that Dr. Acker had ever treated Mr. Kittner?
No.
Dr. Walker, you stated earlier that it was your medical opinion that Mr. Kittner's cause of death was a heart attack. Is that right?
Yes.
Now, on May 9th, once Mr. Kittner began suffering a full-blown heart attack, would there have been an appropriate medical intervention?
One might have administered adrenaline to get the heart pumping again.
Now, are persons trained in the emergent care of heart attacks, are they trained to use adrenaline?
Absolutely.
And doctor, is it possible to form an opinion to a reasonable degree of medical certainty as to what caused David Kittner's heart attack that day?
No, there were just so many factors, so many important factors and significant factors, not any small factor, that I can't say which one of those caused his death.
What factors exactly were there at risk at the time of his death?
As we discussed earlier, there was his drug use, there was his health, there was his lack of exercise, there was the drug abuse, his lifestyle, there was the presence of several substances in his body. All of those were very high-risk factors that any one of those could have contributed to his cardiac arrest.
Thank you, Dr. Walker. Nothing further at this time, Your Honor.
Cross-examination, Your Honor?
Yes, you may.
Dr. Walker, you just talked to us about your knowledge of Mr. Kittner being on Vicodin, right?
Yes.
You know that hydrocodone was found in his system?
Yes.
And you just talked to us about a prescription that you said you saw he obtained about a month before he died.
I believe it was about 2 months, but yes.
Now, you actually know that Vicodin was found in the room with Mr. Kittner where he died, right?
Objection, Your Honor. Have you heard outside the presence of the jury?
Yes?
I believe this is violating a motion in limine. Your Honor ruled that they may go into the fact that there was a bottle found, but not as to what was in the bottle, what it was for, who it was to, etc.
That's fair. Perhaps you could rephrase your question.
Your Honor, if I just may respond, opposing counsel widely opened the door to this line of questioning when they entered a prescription for Vicodin during their direct examination of this expert. Now, I'm going to show that there's actually Vicodin in the room with Mr. Kittner after the prescription that they entered into evidence. They've opened the door.
Counsel, all they've gotten to do so far is put in a document that says that there was a prescription. You get to say that there was a bottle that says Vicodin, but you don't get to say there was Vicodin in the room. That's a leap I'm not going to allow you to do. So if you rephrase your question, you'll be fine.
Yes, Your Honor, may I just clarify outside the presence of the jury, are we allowed to then enter the exhibit, or we're still not allowed to enter the exhibit?
The exhibit can come in. You can talk about the fact that the bottle was found in the room. You can argue to the jury that the bottle contained what the bottle says, but you can't state as a fact that there was Vicodin in the room.
Okay, thank you, Your Honor, I understand. Thank you. Now, Dr. Walker, you reviewed all the exhibits in this case, right?
Yes.
I'm handing Dr. Walker Exhibit 1. Dr. Walker, you've seen that before, right?
Yes.
That's a picture of the bottle, right?
Correct.
And you saw this document before you made any opinions in this case,
I
right?
did.
Your Honor, at this time, we move to enter Exhibit 1 onto the record.
Any objection?
Not if it's being offered, if it's not going to be offered factually or substantively, and it's merely going to be argued that it says Vicodin, there's no objection, Your Honor.
All right. It's admitted for that limited purpose.
Dr. Walker, that Vicodin bottle appears to be a prescription for Vicodin, doesn't it?
To David Kittner Jr., yes.
And you know that David Kittner Jr. lived with his father when Mr. Kittner died, right?
Yes.
And that Vicodin the bottle also appears to be prescribed by Dr. Martin, right?
It appears so.
And there are pills in the bottle in that picture, to the best that you can see, right?
I don't know. I hadn't looked at it that closely. It could be a shadow or it could be pills.
Now, do you still have Exhibit 4 up there in front of you? The Golden Dock Health Clinic
Yes.
intake form?
Yes.
Now, you also talked earlier about reviewing that as part of coming to your opinions today, right?
Yes, ma'am.
Now, at the top of that form, it says who the referring physician was, doesn't it?
Yes.
It says that the referring physician to this health clinic was Dr. Martin, doesn't it?
Yes.
And this intake form was filled in April 21st, 2011, right?
Yes.
Now, I'm done talking about that. If you want to put that down, I would like to talk to you more about the autopsy that you reviewed in this case. Now, you know, as a result of the autopsy, that there were various substances found in Mr. Kittner's body.
There were numerous substances, correct?
And one of those substances was propofol, right?
Yes.
You know a lot about propofol, don't you?
Quite a bit.
You know it's a sedative.
Yes.
And it can be injected, right?
Yes.
And it works rather quickly because it's injected.
Yes.
So it works within 1 to 3 minutes.
Approximately.
And you know that propofol can actually cause shortness of breath, right?
That could be one of the side effects.
It also can affect the heart rate.
Yes.
And you know that propofol is contraindicated with various other drugs.
Just like any prescription.
One class of the drugs it's contraindicated with is opiates.
I don't know if I would use the word, what was the word, contraindicated? Contraindicated? I don't know if I would say that word.
Well, you know that it shouldn't be prescribed with a class of drug called opiates, right?
I don't remember if it should or should not. I think it's you have to use a little bit of caution when prescribing them together, but I don't think it's, and I could be wrong, I don't think it says you can't do it.
So you have to use caution when you prescribe it with opiates?
You may use caution, correct.
And you should also use caution if you prescribe it with hydrocodone, right?
Absolutely, just like with any medication. If you were prescribing Tylenol with Dimetapp, you should probably use caution. If you were prescribing Dimetapp to a 4-year-old or a 3-year-old, you should use caution. Every medication you should absolutely use caution with.
Well, Dr. Walker, we're not talking about Dimetapp and we're not talking about children. We're talking about a sedative and a pain medication. Now, you know that specifically propofol should not be, or should be taken extra caution when it's prescribed with hydrocodone, right?
Yes.
And that's because those drugs together have a negative interaction in the person's body.
They may have a negative interaction.
And as we talked about earlier, and as you mentioned a couple of times, you know that Mr. Kittner was found with hydrocodone in his body at the time he died.
I personally know that. My opinion today is that Dr. Martin didn't necessarily know that.
Right, I understand, but you know now that hydrocodone was found in Mr. Kittner's system.
Hindsight's always 20/20.
You also know now that cocaine was found in Mr. Kittner's system, right?
Yes.
And you would say that it's pretty easy to tell when somebody's on cocaine.
Yes.
You can see it just by looking at the person.
Yes.
And Dr. Martin, to the best of your knowledge, lived with Mr. Kittner before he died?
Correct.
They were together constantly, right?
Correct.
And to the best of your knowledge, the defendant did not observe any signs of cocaine use in Mr. Kittner.
No.
Now, you also talked about adrenaline a little bit earlier, right?
Yes.
And it's your opinion that the defendant did, in fact, inject adrenaline into Mr. Kittner.
I don't know if that's my opinion that he did, in fact, inject it.
Do you not know if it's your opinion because you don't remember, or are you saying that it's not your opinion?
Honestly, I don't remember if I ever said that he actually injected it. I think it's my opinion that it would have been reasonable practice.
Objection, Your Honor. At this point, I would object to beyond the scope of direct. This witness was not called as a fact witness. She's an expert witness to testify as to the cause of death. She wasn't questioned on what happened May 9th, precisely because she wasn't there on May 9th.
Overruled. You can proceed.
I'm handing the witness her deposition testimony. If you could just turn to page 4 of your deposition testimony and read lines 15 to 20 to yourself and just look up at me when you're done.
Okay.
Now, if you could just close the deposition, does that refresh your memory?
Yes.
So it was, in fact, your opinion that Dr. Martin injected the adrenaline into Mr. Kittner in order to save his life, right?
And I just say that the doctor's conduct in administering it. So at that time, I'm not sure who I meant by doctor, but yes, I do say the doctor's conduct in administering it was that he did administer it.
But you know that that adrenaline and propofol are also contraindicated, right?
Correct.
There are two drugs that, again, should not be prescribed together.
Correct. I don't know if they shouldn't be prescribed together. You just have to use caution when prescribing them.
So you have to use extra caution when you're prescribing them together.
Yes.
So if you're a doctor who knows that your patient has propofol in their system already, it would not be appropriate medical practice to then prescribe adrenaline.
I'm sorry, can you repeat the question?
If you're a doctor who knows that your patient has propofol in their system,
Yes.
it would not be good medical practice, a standard of care, to then inject that person with adrenaline.
Objection, Your Honor. May I be asked the question hearing?
Yes, you may.
The objection is for relevance as to what would be the good medical practice. What's at issue here is whether or not Dr. Martin was reckless, not what good medical practice was. And furthermore, the use of a hypothetical is confusing, as question was made.
Well, I'm going to overrule the objection.
Dr. Walker, do you want me to repeat the question?
Yes, sorry, one more time.
Sure. If you're a doctor that knows your patient has been injected with propofol,
Right.
it is not the reasonable standard of care to then inject that patient with adrenaline.
I think I don't see any problems with it at this point. There's nothing that says you can't do that. You would just have to use extra caution when doing that.
So you think that you should use extra caution, but it's still okay to inject two drugs that are contraindicated?
I don't. It would depend on the circumstances. I think that in this case, Dr. Martin abided by the reasonable care and he went by the standard of care provided to him.
But if you were to find out that Dr. Martin did in fact know that Mr. Kittner had hydrocodone in his system, if he was to know that, it wouldn't be the proper standard of medical care, would it?
If he knew that, but in this case, he didn't know that.
Now, it was also your opinion that something else aside from these three drugs we just talked about could have caused Mr. Kittner's heart attack?
Yes.
You talked about a number of other risk factors, didn't you?
There were numerous other risk factors.
You said cocaine is a detriment to the heart as time goes on, right? In fact, all drugs are a detriment to the heart as time goes on.
It's a very broad categorization. I don't know if I would go that far. You need drugs, like prescription drugs, because aspirin actually helps the heart. So that's a drug. I don't think that would actually be a detriment to the heart, but illegal drugs, probably.
Well, you know Mr. Kittner used illegal drugs, right?
Yes.
You know he used illegal drugs for years at a time. And you reviewed the deposition testimony of Dr. Martin, didn't you?
Yes.
So you know that he knew that Mr. Kittner had used various illegal drugs for most of his life.
That was very common knowledge.
And as we already talked about, you know that those 3 drugs, hydrocodone, propofol, and adrenaline, were found in Mr. Kittner's system at the time he died.
They were found and answered.
I'm sorry, what was your objection?
Objection asked and answered, Your Honor.
We are getting a little repetitive, but go ahead.
Dr. Walker, is it your testimony to this jury that it is merely a coincidence that those 3 drugs were found in Mr. Kittner's system at the time he had his heart attack?
I don't think I've ever used the word coincidence.
Thank you. No further testimony.
Redirect, Your Honor?
Yes, proceed.
Doctor, counsel asked you about Exhibit 4, the California Medical Clinic record.
Yes.
Now, referring to that record, is there a section on there where Mr. Kittner was asked to discuss what medications he was currently taking?
Yes.
Does he list anything on there?
Yes, he lists Viagra.
Does he list anything else?
No.
Is there a section on there where he's asked whether or not he uses recreational drugs?
Yes.
What does he indicate there?
He says no.
Doctor, you were asked a lot about propofol and Vicodin and how they interact. Is it fatal to administer propofol and Vicodin together?
It is not fatal.
How do you know that?
There's a piece of paper, or there's a book that we all use, and it tells us, common ways, it tells doctors common ways to administer it and precautions to take. And nowhere in there does it say that it's fatal. It just says to use caution. But as we all know as doctors, you see them in the commercials every day. At the end, there's this huge tagline that says, use caution on blah, 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 and it lists out this 30-second tagline. Everybody uses caution when administering drugs.
Are you referring to the physician's desk reference section on propofol?
Yes.
And is that an authority relied upon by practitioners in your field?
Absolutely.
And is it something you relied upon today?
Yes.
Doctor, based on your review of the record, can you tell what happened exactly on May 9th?
I can't tell you what caused his cardiac arrest on May 9th.
Can you tell us who injected Mr. Kittner with propofol?
After reviewing the record, it appeared as though Mr. Kittner injected himself with the propofol.
Well, Dr. Walker, without getting into what you think happened, were you there on May 9th, 2011?
I was not there. I only reviewed what the autopsy report stated.
Now, is it possible to figure out exactly when Mr. Kittner's heart attack began?
I don't think so.
Is it possible to figure out whether or not his heart attack began before or after he received any injection that day?
No, it could have started long before or long after.
Thank you, Dr. Walker. Nothing further, Your Honor.
Does the defense have a further witness?
Yes, Your Honor. The defense calls Dr. John Martin. May I proceed?
You may.
Please introduce yourself.
John Martin,
Where do you live?
in Armadillo.
What do you do for a living?
I'm a medical doctor.
I want to talk to you a little bit about your education. Can you tell us where you went to college?
Yes, sir. Lone Star University, got a degree in chemistry and a minor in biometrics. Then I went to Lone Star A&M Medical School.
What did you do after you graduated from Lone Star A&M?
Opened up my own private law medical practice.
Dr. Martin, I want to ask you about today's case. How did you come to meet Mr. David Kittner?
I used to live in Turkey, Lone Star, where there's a famous musical festival where musicians come in, and my good friend, or acquaintance of mine, Ted Nugent, introduced me to him.
Did you two get along when you met?
We hit it off. We were several decades ago. We had similar personalities, became close friends.
How did you become Mr. Kittner's personal physician?
Well, every time that festival would come into town, he'd stay at my house, and we got to know each other, and he finally asked me if I would help him when he goes on the road as his personal physician. And eventually I closed down my medical practice and became his sole doctor.
What is a personal physician?
Typically, it's people with high disposable income that they have enough money to have a medical doctor around. Aches, pains, cold, flu. Sometimes that's a luxury people have when they are able to afford it.
Did you travel with Mr. Kittner as his personal physician?
I did. Wherever he went, I went.
And what about when he wasn't traveling?
He was nice enough. He had a home in Armadillo that he allowed me to stay in the cabana out back.
Is that where you were on May 9th, 2011?
I was.
When I asked you about the events of May 9th, where were you in the afternoon of that day?
By the pool, outside the cabana, with my girlfriend, Bree Trevino. We were watching Dances with Stars. Just kind of celebrating we just got engaged.
Were you able to speak with Mr. Kittner that day?
I did. He had made a phone call to me while I was out by the cabana.
What did Mr. Kittner say to you when you called?
Told me he was had some shortness of breath and said that he'd been exercising.
What did you say?
I said, well, I recommend that you slow down, stop exercising. I also asked him if he was doing any drugs.
Was Mr. Kittner open with his drug use with you in the past?
Oh yeah, no, I saw everything. I was his medical doctor, not his recreational doctor.
And what did Mr. Kittner say on May 9th when you asked him if he was on any drugs?
He swore that he wasn't.
After he told you that he was exercising and he wasn't on any drugs, what did you attribute that shortness of breath to?
Look, he's had a long rock and roll lifestyle. He was overweight. The fact that he was exercising surprised me, and I assumed he overexerted himself.
Were you able to see Mr. Kittner personally on May 9th?
I did. He had insisted that I come to his room, and so I did. I'm his doctor, so I did.
I want to ask you about when you went to Mr. Kittner's room. When you arrived there, were you able to speak with Mr. Kittner?
Oh, yeah.
What was said?
When we got in there, I took my medical bag with me. He immediately insisted that I give him some propofol.
What's propofol?
It's a hypnotic drug. It's something that's used usually for sedation, sometimes for anxiety, oftentimes it's used recently in surgery. They started using that because it's a quick, clear sedation and also allows the patient to come out of it quickly and more clearly instead of a heavier narcotic.
Did you have propofol with you when Mr. Kittner asked for it?
Actually, I did.
Why?
I had a pre-filled prescription. I basically have a little syringe with it in there, and I had many other drugs in my medicine kit. I'm a doctor.
Let's be clear, where did you keep that propofol?
In my medicine bag.
Did you have your medicine bag with you when you were in Mr. Kittner's room?
Yes.
Were you willing to give him that drug, propofol, when he requested it?
No, he wasn't presenting with symptoms of propofol.
At the time that he asked you for that propofol, were you aware of any drug use on behalf of Mr. Kittner?
No. Number one, he told me he wasn't on drugs, and I'd been around him for several days before that. He was eating well, sleeping well, which is not consistent with somebody who's using the recreational drugs of his choice.
Were you aware of any hydrocodone use specifically?
No. He told me he was not using anything.
And had he asked you for drugs like this in the past?
He's asked me for medication, and if he wasn't presenting with symptoms that warranted it, I denied it.
The record reflect I'm showing the witness what's been marked in evidence as State's Exhibit 12. Dr. Martin, do you recognize State's Exhibit 12?
I do. This is an email. Let me go back and explain a little bit. So when I was hired to be his private healthcare physician, I was paid and on the contract employment books for Old Star Entertainment Group, who is the management company for David.
So what is State's Exhibit 12?
It's an email from them, from Mr. Ganjo Gutierrez, basically telling me that they had another complaint with David, saying that he's had pain issues and I have not been complying with his requests.
Now, what does this email reference in terms of pain medication to Mr. David Kittner?
Well, it's just basically saying that he's been having pain issues. He's requested medication. I hadn't given it to him. And they were trying to insinuate that if he was in pain, he couldn't perform on the tour.
Were you willing to give him pain medication?
If he presented with symptoms that warranted me giving him medication like that.
Did he ever present those symptoms to you?
Well, often he did, but often he didn't. But then again, he was a substance abuser, so I had to use my medical judgment whether or not it warranted that type of prescription.
Did you ever prescribe Mr. Kittner any sort of pain medication?
No, not for the time period that we're talking about here. I mean, look, if he had some need for pain, due to pain, I would have given him something like that. But I wasn't going to give him pain medication just because he wanted to get high.
Why does the Old Star Entertainment Group, according to this email, want you to give Mr. Kittner pain medication?
Well, they assume that he's being honest about having pain issues, and if he's in pain and I'm not giving him the proper medication, that he wouldn't be able to perform or practice.
So they wanted to give him pain medication so he could practice?
Well, I only assume that, well, they say basically if he's having pain issues and I'm not treating it, he won't be able to perform. You know, I guess that's what David was telling them.
Is propofol a pain medication?
No, it's a hypnotic drug.
If you were trying to get Mr. Kittner up to perform, would you give him propofol?
No, I mean the code name for this is called milk of amnesia. It's a sedative that puts you in la la land. That's not something, you're not going to get up and perform on stage when you're on this medication.
Does this email mention anything about sedating Mr. Kittner so he goes to sleep?
No, sir.
Does it mention anything about giving him a hallucinogen?
No, sir.
And what's your response when Gold Star Entertainment Group speaks to you about this pain medication?
I just responded, I'm on top of it.
What did you mean by that?
I'm his medical care doctor, and I will give him medication as he presents with symptoms that are warranted.
Did that mean that you were going to give him pain medication?
No.
Now, Dr. Martin, going back to when you refused to give Mr. Kittner propofol that day, what happened immediately after you refused to give him that drug?
Well, look, initially well, let me ask you, you're talking about what I did or what I saw?
What you saw.
After I told him I wasn't going to give it to him, I noticed that David Jr. was peeking his head around the corner.
What did David Jr. do when you saw him?
Started cussing me.
What did you do after David Jr. started swearing at you?
Well, I mean, he's a 17-year-old kid. I'm a grown man. I'm not going to have him talk to me like that. And so I walked out of the room.
No. When you walked out of the room, did you bring your medical bag with you?
No. Actually, I walked out in frustration and forgot that I didn't take it with me.
And when you walked out of that room, who was in that room with that medical bag?
Little John and Big John.
Was there propofol
Sorry,
in that?
Little David and Big David, excuse me.
Was there propofol in that medical bag?
Yes, sir. Like I said, I had a pre-filled syringe full of propofol.
And were you able to come back into that bedroom to get that medical?
Yeah, as soon as I realized I didn't have it with me, I went back to get it.
When you went back into that bedroom, what did you see?
I saw David Jr. With a syringe in his hand, and he put it in some of his, he bought a fancy pair of boots, put the syringe in his boots, and also had something in his left hand they put behind his back. And I basically said, "What are you doing? What is that?"
And what was his response after you saw him with a syringe in his hand?
He went back to insulting me and basically told me to get out of here. Old man, creepy man, dirty man, something like that.
Did you give your medical bag at that point?
Yeah, I took it back.
Did you remain in the bedroom after that?
No, I took off, and again, I assessed David. I did a physical analysis of him. I put my hand on the back of his forehead to see if he was having a fever or anything, and I just assumed that he was overweight and had overexerted himself.
On your way out of Mr. Kittner's bedroom, were Mr. Kittner and his son speaking?
Well, I don't know if I didn't hear David Sr. say anything. I heard David Jr. say something.
What did you hear him say?
He said, "Dad, basically, get your lazy butt up and put on a suit. We need to go transfer money from your bank account to mine."
And you said that you told him to put on a suit. When you first walked into Mr. Kittner's bedroom that day, what was he wearing?
Exercise clothes, gym clothes.
And where was he in the room?
First time I got there, he was in the chair.
And what about the second time you came to the bedroom? Where was he?
Second time, he was laying in the bed.
Was he in a chair in a suit at that point when you left?
He was working out. He had workout clothes.
Did you ever get a chance to look inside that medical bag after you retrieved it on May 9th, 2011?
Yeah, and after I looked through my bag, I did notice that the propofol pre-injected syringe was missing.
And what item did you see in David Kittner Jr.'s right hand?
A syringe.
Dr. Martin, did you ever administer propofol to David Kittner on May 9th, 2011?
I did not. There was no need for it.
Did you give him adrenaline?
No.
Did you give him any drug at all?
No. When I left his room that day, I assumed he'd overexerted himself, and I left.
Thank you, Your Honor. Nothing further at this time.
Cross-examination.
Yes, Your Honor. Dr. Martin, you met David Kittner Sr. early in his medical career, didn't you?
His professional career, singing?
I apologize, in his musical career.
Yes, sir. Several decades ago, we were much younger men back then.
Now, you were working in Turkey, Lone Star, I believe, at that time?
Yes, sir. Had a private medical practice.
And you knew a man named Ted Nugget, I think you said?
Yes, sir.
Ted Nugget's a rock star.
Yes, and an avid hunter.
And Mr. Nugget actually introduced you, David Kittner Sr.
Yes, that's how I met him.
You and Mr. Kittner became fast friends, didn't you?
Yeah, we had similar personalities and interests, and we seemed to get along real well.
You let him come live with you?
Not live with me. When he was in town for the Bob Willis Festival, he would stay at my place.
And after a while, Mr. Kittner asked you to come on tour with him, didn't he?
Well, he asked me to be his permanent physician, and when he was traveling, he wanted me to be there with him.
That's right. He hired you, didn't he?
Yeah, eventually he hired me, and then ultimately I was paid through his contracting company.
Well, when he first hired you, he hired you to be his personal doctor. Is that correct?
Yes, that's correct.
Now, you quit your other practice at that time.
I did. I was fortunate that the revenue he was paying me was sufficient for me to close the practice down.
So the only patient you had at that time was David Kittner Sr.?
Yes.
Now, after the two of you were on the road for a while, he actually gave you a place to live here in Armadillo.
He did. He was gracious with his the spoils of his earnings, and he allowed me to live in the cabana behind his house.
Now, that cabana is actually a 3-bedroom house, isn't it?
Yes, 3-bedroom house, 4 bathrooms. It was rather nice.
It was right by the pool, wasn't it?
Yes, one of the perks.
Now, when Mr. Kittner asked you to be his personal doctor, he was still pretty young, wasn't he?
Sure, it was early in his career.
He didn't have any chronic medical conditions at that time?
Not at that time. Like I said, people with disposable income sometimes feel the need for a personal doctor around.
But he didn't have any conditions, even up to including the day he died. He didn't have any chronic medical conditions that you were treating him for.
No, and most people who hire doctors like that don't necessarily have that.
But he did have a famous drug habit, didn't he?
Yeah, David liked to abuse substances, but again, I was his medical doctor, not his recreational doctor.
He liked to abuse substances. In particular, he liked to abuse cocaine, right?
That was his drug of choice.
Cocaine's a narcotic.
Yes, it is an illegal narcotic.
Now, you said on direct that shortly before he died, he had quit using cocaine.
That's what he told me. That's what I observed. I even read an article that insinuated something like that.
Well, I just want to focus on the fact that you believe he had quit.
I did.
Now, you're familiar with a concept called a relapse?
Oh, sure. And David had his relapses.
Well, just to make sure that we all understand what a relapse is when a person tries to quit a drug, but then they may start using it again. Is that right?
Sure. Typically, it's a substance. It doesn't have to be a drug. Sometimes it's alcohol, and they fall off the wagon.
Relapses are common among people who've been using drugs for a long time.
Oh, certainly. And David did have his relapses.
You also know that sometimes a drug addict will quit one drug but substitute another drug in its place.
I've seen that happen.
Now, Vicodin, you're familiar with Vicodin, aren't you?
Sure.
You know that Vicodin was found in Mr. Kittner's system after he was dead?
I learned that after his death.
Now, Vicodin is a narcotic, isn't it?
Yes, sir. Schedule 1 narcotic.
Vicodin is pretty commonly abused by drug users, isn't it?
Yeah, typically happens to people who prescribed it and they stay on it for a time and they end up being addicted to it. And certainly drug addicted people will use that as the choice if they can't find anything else on the street.
Now, you're also familiar with a drug called propofol, aren't you?
Yes, sir.
Propofol, you're aware, was also found in your patient Mr. Kittner's system after he died.
Yes, sir.
Now, you're familiar with something called the physician's desk reference?
Yes, sir. That's kind of the Bible. We all have pharmacology training through the medical medical school, but if we ever have questions about drugs, interactions, we go to that as our source.
And when you say it's the Bible, you mean that it's generally relied upon by medical experts and people in your field, the field of medicine?
Correct. It's a quick reference that's relied upon by medical doctors in my community.
I'm handing the witness what's been marked as Exhibit 6. Dr. Martin, that's the physician's desk reference for the drug propofol.
Yes.
Now, I'd like to talk about a few parts of this and have you read along silently as I read aloud. I'm going to start in the middle of the page, this long paragraph here, the second paragraph, or the first full paragraph.
Okay.
If you could read along silently. The hemodynamic effects of propofol X injectable during induction of anesthesia vary. If injected intravenously, the major cardiovascular effects are increased blood pressure, sometimes greater than a 30% increase, with rapid change in heart rate and rapid appreciable decrease in cardiac output. Did I read that correctly?
Yes, sir.
Now, if you just skip one sentence there and go to the sentence that begins with addition, can you read along silently as I read aloud?
The last sentence of that paragraph?
Yes, sir.
Okay.
Addition of hydrocodone decreases cardiac output and respiratory drive, elevating the risk of cardiac arrest and shortness of breath. Did I read that correctly?
I read it and I agree with it.
And now I just want you to go over to the right where it says drug interactions.
Yes, sir.
Now that describes the type of drugs that may interact negatively with propofol. Is that correct?
That appears what the paragraph says.
And it lists narcotics. Narcotics is in that list of drugs that may interact negatively with propofol. Is that correct?
Yes.
It also lists opiates.
Correct.
It also says other sedatives.
Yes, sir.
Now, you'd also agree with me that these risks we've just talked about, that because of these risks, propofol is generally recommended to be used only in a controlled medical environment, right?
Typically, that's what is recommended, but every doctor has the ability to make medical decisions and when and where they administer medication to patients.
Now, propofol is an anesthetic, isn't it?
Well, it's a hypnotic drug, but it's also used through the process of, typically, like I said, it's usually a pre-dose that's given through surgery.
Well, it induces anesthesia all by itself, doesn't it?
It tends to knock them out or put them into what they call la-la land.
Without la-la land, medically speaking, it can actually be used to induce a medically induced coma, correct?
Yes, with a specific amount of that, and depending on the size of the individual and their prior drug use, it could put them into a coma.
A medically induced coma is the type of state you would put someone in so that you could cut them open and operate on them.
One of the ways, yes.
Now, you talked earlier about whether propofol would stop pain. Dr. Martin, you'd agree with me that if someone is in a medically induced coma, they're not going to feel any pain, right?
Well, it depends how much they've received. If they just received a little bit, they're not going to go into a coma, but if they receive a heavy dose, you can put them into a medically induced coma.
I'm going to take you back to my question. I'm not asking how much they received. I'm saying if you gave them enough to put them in a medically induced coma, they're not going to feel any pain, are they?
Well, that's the hope when you put somebody under.
Now, propofol, because of its risks, is generally recommended to be used with breathing equipment nearby.
Those are some of the measures that could be taking place, but like I said, it depends whether you're going to knock them out or you're just going to sedate them.
So, for instance, it's recommended in the physician's desk reference that you would keep breathing equipment nearby in case they experience shortness of breath.
Sure, that's what the PDR says.
It also recommends that you keep equipment nearby to restart a patient's heart.
Sure, that's what it says.
Now, doctor, you know the risks of propofol because you've had medical training, right?
Sure.
But David Kittner Sr. wasn't a doctor, was he?
No, he wasn't.
David Kittner Sr. was a drug addict.
Oh, he was an addict, for sure.
He was an addict who gave you a place to live, wasn't he?
Well, first of all, he was my friend who suffered from addiction, and I was his doctor, and he allowed me to live at his house.
Now, you got paid a salary for being his doctor, didn't you?
I did. I was paid a very handsome salary.
Very handsome means $1.8 million a year, more or less.
Sure, I'm a medical doctor. That's not a large amount.
Now, you talked about Exhibit 12 on direct. Do you have Exhibit 12 in front of you? I can bring you a copy if not.
Well, stand by.
That was the email you mentioned?
Yes, sir, got it.
Now, you sort of characterized some of this for the jury, but I want to make sure that we have it. The jury knows exactly what we're talking about, and then we can talk a little more about it. So I'm going to read the portion that was sent to you beginning with John, and I'd like you to just make sure I read it correctly and tell me at the end if I got it right.
Very well.
John, we've had another complaint from David about your refusal to treat his, quote, pain issues. He says you're spending less and less time with him and more time with Tats. We want to remind you that we agreed to pay your $150,000 per month salary on the condition that you have David ready for his, quote, I'm That Guy tour in June. This is pretty simple. David can't perform if he doesn't practice. David can't practice if he's in pain. We certainly don't want to interfere with your, quote, professional judgment, as you call it, but we may need a second opinion from someone who is more on top of the job and less on top of Tats. Please take care of this. Did I read that correctly?
Your diction was outstanding.
Thank you. Now, your response to that email is at the top here, isn't it?
Yes.
And your response is on top of it.
Sure.
Now, this email was sent, the first one that was sent to you was sent at 8:03 a.m., correct?
That's what it says.
May 9th, 2011?
Correct.
And your response was also sent at 8:03 a.m., May 9th, 2011?
Yeah, I was on the computer and got it when it came in.
Now, after you got this email saying that the label might look for a second opinion, you got a call from David Kettner Sr., didn't you?
Well, it was several hours later. He didn't call me until the afternoon.
It was the same day, wasn't it?
Oh, yeah.
And when he called you, he said he wasn't feeling well.
Well, he's having shortness of breath.
Now, you grabbed your medical bag, didn't you?
I did.
And you went to his bedroom?
I did. That's where he told me to go.
In the mansion?
Well, it was the house, yes.
Now, you carried propofol with you into that bedroom, didn't you?
Correct. I had my medicine bag with all my medical doctor equipment. I had other medications, and that was one of them.
Now, doctor, you weren't planning to operate on Mr. Kettner that day, were you?
No.
You weren't going to perform brain surgery in his bedroom, were you?
No, that's not what I went there for.
Now, you didn't take any breathing equipment with you, did you?
Didn't need it.
You didn't take a defibrillator to restart his heart.
And that's not what I was called there for.
And when you got there, David Kettner Sr. asked you for propofol, didn't he?
He did, and I said no.
Hold on a second now. He asked you for propofol by name, didn't he?
Those are the words he spoke to.
Why do you think he asked for propofol, doctor?
Objection, relevance, speculation.
Sustained.
Doctor, he asked you for propofol before, hadn't he?
He's asked me for a lot of drugs.
In fact, you've given him propofol before, hadn't you?
Nope.
Doctor, you carry propofol with you in your medical bag at all times, don't you?
It was in the bag that day.
It was not only in the bag, doctor, it was in a pre-loaded syringe.
It was.
So when you got into that room, if you needed to give him some propofol, all you'd have to do is push that plunger. Is that right?
That's typically how it works.
And David Kettner Sr. is your one and only patient. Is that correct?
Objection, asked and answered.
Overruled.
Is it true that David Kettner Sr. is your only patient?
He is my sole patient.
Thank you. Nothing further.
Your Honor. May I proceed?
You may.
Dr. Martin, you're asked a lot about this email. First, does this email threaten to fire you if you don't provide pain medication?
No, that's not what I took from it.
And is propofol pain medication?
No.
You mentioned or spoke on direct about how propofol puts people into a medically induced coma.
Well, depending on how much they receive, yes, you can induce a coma.
Can people get on stage and play the guitar when they're in a medically induced coma?
I would not think so.
Was Gold Star Entertainment asking you to give him medication so he could practice?
Objection, Your Honor. Speculation.
Sustained.
In this email, do they say why they want you to give Mr. Kittner pain medication?
Presumably, if he's in pain, it was their assumption that he could not practice or go into it.
Could he practice if he had propofol in his system?
I wouldn't think so. Like I said, it puts you in a la-la land.
Thank you, Your Honor. Nothing further.
Anything?
Excuse Judge?
Oh, yes. I'm not sure that the jury will excuse you, but I will.
I'll have to settle that one.
I'd like to give you your time.
Anything further from the state? Anything further from the defense?
No, Your Honor, at this time the defense rests the case in chief.
Nothing further.
Any
from the
rebuttal?
state. No, Your Honor.
Then are we prepared to proceed with closing argument?
Yes, Your Honor.
Your Honor, if we could have a brief 5-minute recess as well as a time check before closing arguments.
That seems fair. The court will stand in recess for 5 minutes.
Prosecution, you have 17 minutes and 46 seconds. Defense, you have 19 minutes and 48 seconds. Thank you. You're welcome.
Is the state prepared to proceed on closing?
Yes, Your Honor. Before I begin, I'd just ask if we can assume that jury instructions will be read after the closing arguments.
Yes, that's the way my court does it.
Yes, Your Honor. Moment set for. May it please the court?
I hope it will.
Makes two of us. Now, members of the jury, David Kittner Sr. is dead because the defendant stopped acting as his doctor and acted as his drug dealer. Now, the victim and the defendant each had an addiction. David Kittner Sr. was addicted to cocaine. The defendant was addicted to a lifestyle. He got to live in a nice house, the sprawling grounds of a mansion. He got to hang out with rock stars. His entire job consisted of seeing one patient, which meant that he got to spend his days drinking and smoking weed by the pool. This was an easy life, a life he'd gotten used to, a life that on May 9th, 2011, required him to enable a man with a drug addiction. On that date, when David Kittner Sr. asked the defendant for propofol, the defendant didn't act as a doctor. He acted as a drug dealer. Now, we heard the story of what happened on May 9th, 2011 from the witnesses in this case. We know that the defendant was in his house, the cabana, that afternoon, and he got a phone call from David Kittner Sr. Now, we read you the testimony of Bree Trevino. We saw that call. She saw the defendant hang up the phone. She saw him gather up his medical bag and then head inside the mansion. Now, once inside Mr. Kittner's bedroom, Mr. Kittner's son was nearby. He overheard his father yelling about needing pain medication. David Kittner Jr. then went to his father's bedroom, poked his head in, and he saw the defendant standing over his father holding a syringe. He said he saw the defendant push that plunger and inject a drug we now know was propofol. Now, at that point, the defendant said, "You just can't leave this stuff alone, can you?" And he put that syringe in his jacket pocket. He turned around and he noticed David Kittner Jr. was watching him commit that criminal act. So he ran out of the room. David Kittner Jr. was watching, and he said just moments later, after that injection, he saw the color leave his father's face. He knew something was wrong. He yelled for help. He yelled for the doctor to come back. He ran into the hall and yelled for him to come back and help. David Jr. told us the defendant came back. He saw him rifle through his medical bag and pull out another substance to inject. Substance we now know was adrenaline. David Kittner Jr. watched as his father took another turn for the worse, and then he watched the defendant leave the room yet again. The trained doctor left a 17-year-old alone in that room to call 911 and wait for the ambulance as his father lay dying. As the representatives for the people of Lone Star, we had the burden of proof in this case. Now, we proved three things to be beyond a reasonable doubt. First, we proved that the defendant administered a drug that caused the death of David Kittner, and that he administered that drug. Secondly, we have proved that he administered it recklessly. And third, we proved that it did in fact cause his death. Now, first, we know that the defendant administered the drugs found in Mr. Kittner's system. We know this from the eyewitness testimony in this case. David Kittner Jr. told you that he saw the defendant push that plunger on that syringe and put that propofol into his father's system. And after that dangerous sedative sent his father into cardiac arrest, he watched as the defendant administered adrenaline to try to bring him back. Now, the defense may try to tell you that David Kittner Jr. was lying about what he said. But his testimony doesn't stand alone. The independent, verifiable, can't lie to you evidence proves he's telling the truth, because it shows that the defendant had planned to give Mr. Kittner propofol that day. And we know this first from the testimony of Bree Trevino, which we read to you today. She told us that when the defendant hung up that phone and picked up his medical bag, she heard him say, "I'm going to go fix it once and for all." What does she mean by that? What did the defendant mean by that? He meant he was going to go give David Kittner Sr. the propofol he wanted so that he would shut up and leave him alone, and the defendant could get back to drinking and hanging out by the pool. Now, we also know that the defendant had planned to give Mr. Kittner that drug from his own testimony. And that's clear when we remember that propofol is a tool. It's made to be used for a specific purpose. Now, if you've ever been locked out of your car and had to call AAA, you've probably seen that long metal tool that's used to open a locked car door. Now, a locksmith can use that tool to help people, but it can also be used to steal. Now, if you heard that a man who worked for AAA took that tool with him every time he went to work, you'd probably think, that makes perfect sense. But what if you heard that that man worked as the receptionist at AAA corporate headquarters, and there was no chance he was ever going to be asked to go out and help someone get into their car? What would your common sense tell you if that man walked to work every day carrying a tool made for breaking into cars? Would you think he was going to use it the right way? Would you be surprised if one day he was caught driving a stolen car? Now, the defendant told us himself that on the day he went in David Kittner Sr.'s room, he carried a syringe already filled with propofol. We heard that propofol, just like that lock-picking tool, has some legitimate uses. It can be used to sedate people. It can be used to put people into a medical coma, anesthesia. It can be used for people suffering from anxiety attacks to sedate them. But we also heard that that drug can be abused by recreational drug users. Now, we know that syringe was intended for Mr. Kittner because the defendant only had one patient. And we know that he wasn't going to use it to induce a medical coma. Because he told us he wasn't planning to operate on Mr. Kittner that day. He wasn't going to perform brain surgery in the master suite of the mansion. And we didn't hear any testimony today about Mr. Kittner suffering from anxiety. The defendant carried that propofol into the room because he was in the habit of giving it to his patient. And we got even more evidence of that from his statement on cross-examination. The defendant admitted much more than he meant to when he told us that on that day, David Kittner Sr. asked for propofol by name. The fact that the victim knew the name of this incredibly specialized drug shows that he was in the habit of asking the defendant for it. It shows that he knew the defendant would have it with him. It shows that he knew he could get it if he asked his live-in drug dealer for it. And he knew he could get it that day in particular because he knew that his record label had sent this email to the defendant demanding that he either deal with David Kittner Sr.'s request for pain medication or they'd look for a second opinion. And then away would go the $150,000 a month salary. The defendant walked into that room that day carrying that propofol because he knew that his job and his cushy life were on the line. Now, when defense counsel and I are done with our closing arguments, the judge is going to give you instructions about how to decide this case. And he's going to tell you to use your common sense when you review the evidence. Common sense, along with the testimony, the eyewitness testimony in this case, showed that the defendant was the one who administered propofol to David Kittner Sr. And it also shows that he was the one who administered adrenaline to David Kittner Sr. Now, we also proved that doing so was reckless. We showed that there was a substantial risk. We showed that that risk was unjustified. And we showed that the defendant consciously disregarded that risk. But Dr. Jensen explained why there was a substantial risk in administering propofol all by itself. She told us that propofol can cause high blood pressure, can cause shortness of breath, it can cause cardiac arrest. And the defendant had to agree to that on cross-examination when confronted with the physician's desk reference, which he called the Bible in his field. The defendant also told us, as we read through that the risk of administering propofol get even worse when you mix it with a drug like hydrocodone, narcotic, and an opiate. Now, as big a risk as the defendant took by administering propofol that day, he took an even bigger risk when he then administered adrenaline. Dr. Jensen told us that administering adrenaline in the presence of propofol and hydrocodone is almost certain to cause a cardiac event like the one that killed David Kittner Sr. Now, the defendant wants us to believe that he didn't know that his patient had taken hydrocodone. He didn't know that David Kittner Sr. was on drugs. But he had to know it was possible that David Kittner Sr. had taken other narcotics that day. He lived and worked with the man for decades. And every witness in this case told us that he had an infamous drug habit. Because of the incredible risks of mixing propofol and hydrocodone and adrenaline, the defendant should have done more than simply hope that his patient was sober that day. He should have made sure. Now, there were two pretty clear indications that his patient wasn't sober that day. One, that David Kittner Sr. asked the defendant for propofol. And two, a piece of evidence that the defendant somehow managed to ignore or has simply lied about. This pill bottle found on David Kittner Sr.'s bed. Now, I'm not going to tell you that I know what's in that pill bottle. It doesn't matter. Because what it says on the pill bottle is Vicodin. That's hydrocodone. That's the drug that mixed with the other two and caused all of these risks. Now, regardless of what was in this bottle, we know there was hydrocodone in David Kittner Sr.'s system, and we know that this would have been a big orange warning sign to the defendant if he'd simply opened his eyes and looked down at that bed while he was injecting his patient with propofol. All he would have had to do to avoid killing his patient was simply look at what was in the room that day. But he ignored the signs, he ignored the risks, and he consciously gave Mr. Kittner those injections. He consciously disregarded all the risks, and members of the jury, that's reckless. Now, finally, we proved that the defendant's recklessness caused the death of David Kittner Sr. Dr. Jensen, the chief medical examiner here in Barrett County, told us she performed the autopsy on his body, and she concluded, with the help of tox screen analysis, that 3 drugs combined to give Mr. Kittner a massive heart attack. And those 3 drugs, the hydrocodone that the defendant should have known, and the 2 drugs that we know the defendant administered, propofol and adrenaline. Members of the jury, we proved beyond a reasonable doubt that the defendant committed manslaughter. Now, I don't doubt that it would have been difficult for the defendant to say no to David Kittner Sr. that day. It would have been difficult to say no to the record label that was telling him his job was on the line. That was his job. That was his duty. It was his duty not to buckle under the pressure. It was his duty not to sell out his oath and become a drug dealer. And as much as David Kittner Sr. might have wanted to fix that day, as much as he might have asked his drugs, as much as he might have bullied his friend and doctor to get those drugs, he still trusted that his doctor wouldn't do anything that would kill him. Find the defendant guilty of manslaughter because on May 9th, 2011, David Kittner Sr. needed someone to protect him. He needed a doctor. But all he found was a drug dealer. Thank you.
Yes, please.
David Kittner was on the road to destruction. He let his drug usage control and define his life, and ultimately, he let it end his life. And it was David Kittner, and not Dr. Martin, who was responsible for the propofol in his system on May 9th, 2011. And it was David Kittner's lifelong drug usage, his obesity, his bad eating habits, his bad exercise habits, and the symptoms that he suffered weeks before he was ever injected with anything. It was those that ultimately led to his death. Make no mistake, folks, it was David Kittner himself who was responsible for the propofol in his system, because he asked his teenage son to give it to him, and his son did. Remember what you heard about David Kittner Sr. He was a rock star, a musical legend. And David Jr. told you that his father traveled when he was growing up. He was gone a lot. David Jr. didn't grow up taking camping trips with his dad or going fishing. He grew up reading about his dad in the tabloids, watching him in concert. He grew up admiring his father just like every other fan did, from afar. But on May 9th, 2011, Mr. Kittner Sr. was home, and David Jr. was right there with him. And when he saw Dr. Martin refuse to give his father pain medication that his father had been ranting about in the house, he saw an opportunity to help the man who had everything.
And so when Dr. Martin was out of the room, he reached into the medical bag that Dr. Martin told you he left there, and he gave his father propofol. And David Jr. told you on the stand today that he was alone with his father. And you know now, after hearing the evidence, that in those few minutes they were alone, it was him, his father, and Dr. Martin's medicine bag that contained a preloaded syringe of propofol. We know David Jr. sought his father's approval. He told us so today. He said every son seeks his father's approval. And he got it. Because he heard the 4 words that his father always told him when he approved not just of his son, but of something his son did. He said to him, "Rock on, little kid." And what do you think David Sr. meant when he approved of his son? When he approved of something his son did? Because it certainly wasn't the shouting and cursing at Dr. Martin. No, it was the fact that he grabbed the propofol, hid it in his boot, and then injected it into his father, just like he asked. And that was easy. Injecting someone doesn't take extensive medical training. If it did, well, then our heroin problem in this country would probably be a lot smaller. But I can tell you that when flu season came around, my flu vaccination would cost a lot more than $10 to $15 at the local Walgreens. David Jr. wasn't performing heart surgery that day. He took a needle and he stuck it into his father's arm, just like his father asked. So we know that Dr. Martin didn't inject his patient with propofol that day, because David Jr. did. But why else do we know that Dr. Martin would not have injected his patient? Well, we know because Dr. Martin had zero motive to be reckless and every single reason to be careful. You heard today that Dr. Martin had one patient who was responsible for his entire job, his career at that point, and a large income. You don't kill a golden goose. This man provided him with everything he had, his job, his income, and even his home. Dr. Martin lived in Mr. Kittner's guest house. He had no reason to put all of that on the line on May 9th. And we even know that the evidence shows Dr. Martin had always been careful in the past. Counsel made a big point of telling you about this email. An email sent from Mr. Kittner's agents to Dr. Martin. And it said that they had another complaint from David about his refusal to treat his pain issues. Another complaint. Dr. Martin had been refusing pain medication to his patient several times for months. And every single time he'd said no, so many times that Mr. Kittner had complained over and over again. The prosecution called Dr. Martin, they said that he went from being a doctor to a drug dealer. Well, then he must have been the worst drug dealer in the world, because he's getting repeated complaints about not giving his patient drugs. And what's more, remember that they stressed a lot that he had Vicodin in his system. Folks, you saw one prescription for Vicodin today, and it came from a Dr. Rodney Acker. And ladies and gentlemen, why would someone who has a personal physician at their beck and call 24/7 go to another doctor to get drugs? Because that's exactly what happened in this case. Mr. Kittner had Dr. Martin literally in his backyard, but he went to another doctor to get pain medication, the thing that Dr. Martin had refused him over and over again. The only reason he would do that is if Dr. Martin couldn't give it to him, didn't give it to him, and continually refused it to him. And that tells us something very important. That tells us that Dr. Martin is not the Dr. Feelgood that the prosecution has made him out to be. He wasn't a pill dispensary. He was very careful with his patient's care. He didn't give him what he wanted. He only gave him what he needed. The evidence proves that. What's more, the prosecution read to you testimony from Bree Trevino, an unavailable witness. They read to you a line where Bree Trevino said she heard a conversation between David Kittner and Dr. Martin, talking about needing some pain medication to help with chronic pain caused by an old injury. She said that conversation between Mr. Kittner and Dr. Martin happened about 6 weeks before his death. The prescription was prescribed March 12, 2011, right about 2 months before Mr. Kittner's death. This shows, in fact, that Dr. Martin said no. Beyond just the multiple complaints that Mr. Kittner had given, every piece of evidence in this case shows that Dr. Martin refused pain medication over and over again, and he had no reason
to act differently on May 9th. Now, ladies and gentlemen, on May 9th, 2011, the prosecution alleged that Dr. Martin gave propofol because of the email. Remember, they said the email said he was being threatened if he didn't give Mr. Kittner what he asked for. But you heard what the email said. They said that Mr. Kittner was complaining about pain issues and that he needed to be able to play. Well, what is propofol? It's a sedative, right? It's not a pain medication. Even in large dosages, as were administered here, it's still not a pain medication. It's a sedative. It would cause hallucinations. It would knock someone out. The prosecution referred to it as something that could cause a medical coma, I believe. Does this seem like the thing that someone would give a man to be able to practice guitar, to be able to sing songs on tour in a concert? Something that could cause a medical coma? No. He had no reason to give propofol that day. And that's why he responded on top of it. He had been on top of it for months. He wasn't changing his opinion. As the company complained, and you heard today, he was always using his professional judgment. That was Dr. Martin's #1 priority. But we also know, besides all the evidence that shows Dr. Martin wouldn't have injected this, we know that no doctor would have injected this. The dosage tells us that alone. 3 times the amount of propofol was found in Mr. Kittner's system. 3 dosages. An amount that has no medical usage, but a remarkable hallucinogenic effect. In other words, an amount that someone would use to get high. And only one person in the room that day had a lifelong habit of trying to get high. Mr. David Kittner. Now, a physician with medical training would know to be able to read the dosage markings on a syringe. But someone untrained medically, a teenage boy for instance, would not know. Now folks, it's clear that David Jr. is not on trial here today. But the fact of the matter is the state has relied on one person to tell you about the facts of May 9, 2011. And that person is David Kittner Jr. So because of that, we have to consider the holes in his story. And there's one gaping hole. Remember, David Jr. told you that his father was injected on the bed. And that after he was injected, his father began suffering seizures and convulsions on the bed. And after that, he received a second injection, as David claimed today, and that he stopped breathing on his bed. But ladies and gentlemen, where was Mr. Kittner found? Sitting in his chair, wearing a suit and tie. To believe David Jr.'s story, we would have to believe that after his father stopped breathing on his bed, he then woke up, cleaned himself off, recovered from his seizures and convulsions, and moved to the chair. Or maybe it's just that this teenage boy, David Jr., was the incredible Hulk of teenagers, because he was able to move his 230-pound unconscious father from the bed to the chair. Any way you look at it, David Jr.'s story doesn't make sense. And that's because he's not telling you the truth today. David Jr.'s holes don't add up. He's covering for the sad truth that a father used his son to get high. And that went tragically wrong. Now, ladies and gentlemen, maybe the one thing that can give David Jr. some solace in this case is that we don't even know for sure if the propofol is what caused Mr. Kittner's heart attack. Now, as I expect the honorable judge will instruct you, it was the state's burden today to prove to you beyond a reasonable doubt, not only that Dr. Martin injected his patient, but that that injection caused his death. And the state has fallen far short of that burden. So you heard today a lot about the drugs in Mr. Kittner's system, propofol, Vicodin, adrenaline, but there were some more drugs in his system. You heard about cocaine, THC, ketamine, and a chemical mixture of sodium hydroxide and aluminum powder. Folks, Dr. Jensen got on the stand today and told you that even though all these things were present in his system, she was sure that it was just the propofol and Vicodin and hydrocodone. But You heard evidence from every doctor today that cocaine causes serious damage to the heart, that long-term usage causes even more damage to the heart, and that it directly puts someone at risk for a cardiac event. Exactly the thing that everyone agrees Mr. Kittner died of. And what about ketamine? What does that do to Mr. Kittner's heart? Or sodium hydroxide and aluminum powder? What do you think that did to his risk for a cardiac event? Because you don't need a medical degree to know that those things probably weren't good for him. You heard a doctor testify today, those weren't medications. They were drugs found in his system, toxins. And that was just that very day. That was just the day he died, because we know Mr. Kittner had a lifetime of drug abuse, a lifetime of cocaine usage, of experimenting with drugs. And we know that before he ever called his doctor on May 9th, he experienced symptoms of cardiac stress. 2 weeks before he died, he went to a California clinic complaining of the exact same thing he suffered from the morning of his death, difficulty breathing. He'd been suffering from that for almost 48 hours when he went to that clinic. Even judging by the most objective source you heard from today, the physician's desk reference, it's clear that we can't tell whether the propofol and Vicodin in fact triggered a heart attack. There's an entire section in that book on how to administer the two together. The reason there's a section in there on it is because you can administer them together. It's not fatal to do so. Everything in the physician's desk reference says it merely elevates the risk. So the fact that the two were in his system doesn't prove that that's what caused his heart attack. It proves that he had elevated risk. And that's something that everyone agrees on today. Mr. Kittner had an elevated risk for a heart attack because there was a laundry list of things that elevated his risk. His obesity, his bad eating habits, his exercise, the fact that he was a traveling musician. He had a life full of stress. The fact that he had a lifetime of drug abuse. Every single one of those things elevated his risk. And then on top of that, a long list of drugs was found in his system that day. It's impossible to know for sure which of those actually caused Mr. Kittner's heart to stop. Now, Dr. Jensen was the only person who gave you the opinion that those stopped Mr. Kittner's heart. But remember, when Dr. Jensen testified, my partner, Mr. Vittori, in fact impeached her on those very opinions. Remember, she had inconsistent opinions. In her testimony, she first said it was just the hydrocodone and the propofol that caused the death. But then later, no, it was all three. It was the propofol, the hydrocodone, and the adrenaline. And that wasn't the only time she had an inconsistent opinion. Because remember, she got on the stand today and she told you it was her opinion that Dr. Martin injected the propofol. But what did it say in her own autopsy report? It said the decedent apparently injected propofol in the presence of hydrocodone. The decedent. Dr. Jensen got on the stand and gave you a lot of conflicting opinions today. And that's because it's impossible to give an opinion as to what caused Mr. Kittner's death. And you know you can believe Dr. Walker on that point. The prosecution also showed you a bottle of Vicodin that was found. They told you to consider the fact that Dr. Martin must have known his patient was using drugs. And to consider, I believe on opening statements, counsel referred to the fact that this wasn't even prescribed to David Kittner Jr. It was likely prescribed to David Kittner himself, really to give it to David Kittner Sr., the drug addict. But if that's the case, then let's look closely at what this means, because here you see the prescription says November 17th, 2010, 6 months before Mr. Kittner died. And the quantity is 30. And right up here in the corner it says no refills. Are we to believe that a drug addict is going to parcel out 30 pills over 6 months? A lifelong drug addict would be averaging about 1 pill a week. No. Vicodin may be a prescription strength painkiller, but it's not a horse tranquilizer. It's not going to knock someone out for a week. If Mr. Kittner had this in his hands, if a 65-year-old lifelong drug abuser had this in his hands, it would have been gone like that. It's not just that the state hasn't proven their case, it's that they can't prove their case. Because Dr. Martin didn't do this. All the evidence shows that David Jr. succumbed to what his dad said.
So it comes down to what you believe is reasonable. Do you think that it's reasonable that a physician would put everything on the line on May 9, 2011? Or do you think that it's reasonable that the teenage son of a rock star is impressionable? That when his father asks him to do something, he'll do it. Because if you think that's reasonably possible, then you cannot find Dr. Martin guilty of this crime. And now that you've had a chance to hear all the evidence in this case, I'm confident that you'll return the only verdict that fits with that evidence and that justice demands. You will find Dr. Martin not guilty. Thank you.
Rebuttal from the state.
Gaping holes. Defense counsel wants to talk about gaping holes. Let me just briefly address this picture right here. She said this is a gaping hole in the prosecution's story. Well, it's only a gaping hole except that you remember that David Kittner Jr. told you how he must have ended up in this chair. He said the EMTs must have moved him to his chair. Now, I don't know why, but I'm not an EMT. He said he must have done it, so what must have happened? Now, the defense wants to point out that he's in a suit and said that that's a gaping hole because we heard he was in his workout clothes. We heard he was in a t-shirt. Members of the jury, who did we hear that from? The defendant himself, and only the defendant. You want to talk about a story with a gaping hole? The defense just told you a story in which David Kittner Jr. comes into that room and he sees a medical bag and he opens it up and he finds a syringe and he injects his father. What's the problem with that? It's been bugging me. That syringe, we heard from the defendant himself, was preloaded with propofol. And counsel said, well, you don't need any special expertise to give someone a syringe. But members of the jury, would you recognize a syringe pre-filled with propofol? If someone asked you to give them a syringe filled with propofol and you opened a bag full of stuff, would you know which one had propofol in it? Now, we didn't need to show the defendant had a motive to kill the golden goose, but he had a motive to do whatever Mr. Kittner asked him, $150,000 a month worth. And that day, David Kittner Sr. asked him propofol. The defendant gave it to him. Find him guilty.
I want to thank counsel for both sides. This concludes the evidence. Ordinarily, we would excuse the jury to deliberate, but we're going to excuse counsel and the gallery so that the jury can deliberate. Counsel should not leave or pack up. Losing counsel is going to be asked to take mug shots for your sanctions hearing. Winning counsel will be taking